Hello, good morning, and welcome to Byju's Exam Prep. Today, we formally launch the CSE 2024 batch, and we'll start with Indian Polity. But this may not be your first class. You may have been attending these classes previously, but we will consider that this is your class 1 of batch CSE 2024. So first, I'll give you a brief overview of what this program, what this course is all about, and then we will start with Indian Polity Lecture 1. First thing that you have to keep in mind, you should expect something from us, and then you should have expectations from yourself as well. What is it that you can expect from us? We'll give you all that is required to help you ace the civil services examination. Classes, material, notes, mentorship, whatever is required for you to excel in this examination. But at the end of the day, you have to attend these classes. At the end of the day, you have to revise the books that we provide you. At the end of the day, you'll have to write answers, share your answers with us so that we can provide you with the feedback. Unfortunately, we can't give your exam. You will have to fill your form yourself. We can assist you with how you can fill your form. But at the end of the day, you'll have to write the exam yourself. Unfortunately, your teachers cannot write the exam on your behalf. So whenever you do something, you should always be clear about the expectations. What do you expect from an institution, and what should be the expectation from your side? For example, right when you start, we are providing you with a year-long timetable. For example, this is the year-long timetable for the morning batch. If you have enrolled now, which means if you look at this timetable, by 17th January 2024, your entire syllabus would be complete. So whether it is prelim syllabus or main syllabus, your entire syllabus will be completed on 17th of January 2024. This if you're attending the morning classes regularly. When the classes are scheduled, that's provided to you, that's available on the screen, that's also provided to you over your mail. For example, the year-long timetable. So polity, then economics, then modern history, then geography, all the subjects of this civil services examination, we shall be completing for you on 17th of January 2024. But what if you have time and you want to take both the batches simultaneously? You want to appear and attend the classes in the morning, and you also want to attend the classes in the evening, which starts today 5 p.m. till 8:30 p.m. in the evening. There we will start with modern history and post-independent India. Then we will shift to geography, then with polity. And then you would also realize that in the evening batch also, on the 17th of January 2024, the entire syllabus would be complete from prelims as well as mains perspective. But there may be a student who have all the time. In a sense, you're preparing for this examination full time. You're not working in an organization. You're not studying in any other university or a college. You have all the time in the world and you want to complete the syllabus as quickly as possible. Then you can also attend the weekend batch, which starts on February 4th, only on Saturdays and Sundays. And there we start with economics. And you would realize that there are subjects which do not overlap. In a sense, in the morning, we will study polity. In the evening, we'll study modern history. Over the weekend, we will study economics, which means if you have time and you can attend all the 3 batches at the same time, which means in 1 month, your 3 major subjects would be complete. But that may also be a big burden on your shoulders, which you may not be in a position to handle. So what I would suggest, you only pick one batch, whether it is morning or evening or the weekend, and stick with that batch. For example, if you're attending the morning class today, stick with the morning schedule for your entire course duration. And you would realize that in morning, we will complete the entire syllabus by 17th of January. But if you have time, you may take up morning as well as evening batch. If you have time, you may take up morning, evening, as well as the weekend batch. But I would suggest that you stick to one batch and stick it for the entire duration. That's number one. Number two, apart from this, as soon as the class ends, we will give you an additional reading material in question and answer format, which is like, for example, you're attending an offline class. The teacher is teaching a particular concept, but there are good students in the class who ask very good questions, genuine questions, intelligent questions. What we do, we pick these important questions that have been asked by the students in the live class, and in a question and answer format, we give you a document at the end of the class that is known as additional reading material. So once the class is over, go through the annotated PPTs. For example, whatever I'm writing on the screen, we save it and we give it to the students. It's available on the app. Number one. Number two, once the class is over, you are given an additional reading material as well. Please go through that material as well in a question and answer format. That's going to help you. How? If you're attending an offline class, you are benefited from the wisdom of a teacher. The teacher is delivering content, but there may be 10, 20, 30 students who are intelligent students in the class who ask very good questions. So in this class, you are benefited not only from the wisdom, by the wisdom of the teacher, but also the wisdom of the other good, intelligent students. That's the kind of benefit we want to provide students in an online class as well, because you do not interact with other students. But these good 10, 20, 25 questions that appear in the live class, we pick these questions, and in a question and answer format, in an additional reading material, we give you this document so that the benefit of an offline class is also given to you in an online class. You are benefited from the wisdom of 10, 20, 30 good, intelligent students in a live class as well. Clear? And then we also give you books. Some standard 17 books are provided to you. So whether it is the live class, live lectures, morning 6 to 9:30 a.m., then additional reading material, then the annotated PPTs and the books that we provide you. After that, from content perspective, you don't need anything. Your content is clear, which means after that, you have to revise. After that, if you have doubts, you have to speak to the mentor. After that, if you have any confusion, you can write a mail to the teachers as well, and they will reply. But then what about current affairs, which is an important, a significant component of your civil services syllabus? For current affairs, every Tuesday and Thursday, we have live classes. For example, Tuesday from 8:30 to 10:30 p.m., Thursday 8:30 to 10:30 p.m. What do we do? What do we cover in these two live classes in a week? We cover current affairs. But how do we cover current affairs? Tuesdays are specifically focused on the prelims exam. So prelim specific content will be given to you in a Tuesday's live webinar, 8:30 to 10:30 p.m. What are the sources that we cover? Any source which is relevant for the exam, whether it is the Hindu newspaper or the Indian Express, Yojana, Kurukshetra, PIB, any source that is relevant for this exam. We cover all these sources so that we give you prelim specific content on Tuesdays. But Thursday's webinars are split into 4 areas. The first Thursday of the week will be focused on GS1 and GS2, but from mains perspective. Because you would know that prelims examination, UPSC focuses on 2 things, facts and concepts. Whether you have factual understanding about a particular topic, whether you have the conceptual clarity about a particular topic, that is something that UPSC tests you on. Whether you have the factual knowledge, whether you have the conceptual clarity. When it comes to the mains exam, UPSC focuses on 2 things. Whether you can elaborate whatever you have studied for your prelims exam, whether you can analyze whatever you have studied for the prelims examination. Which means prelims is about 2 things, facts and concepts. And mains exam is about 2 things, elaboration and analysis. of the same facts and concepts that you've studied for your prelims examination. So our Tuesday's webinars will be focused on facts and conceptual clarity, which is required for your prelims examination. And Thursday's webinars will be focused on the mains examination, where the first Thursday of the week, we will cover current affairs from the mains perspective relevant for GS paper 1 and 2. Second Thursday of the week, we will cover current affairs from the mains perspective relevant for economics and many other subjects which are part of GS paper 3. But the third Thursday of the month, we will be specifically focusing on environment and ecology, science and technology, because look at the trend of the questions that appear in the civil services examination. There is, over a period of time, a strong domination of environment and ecology and science and technology when it comes to not only prelims as well as the mains examination. So the third Thursday of the month, we will be specifically focusing on the current affairs relevant for your mains examination from two important areas, environment and ecology and science and technology. And the fourth Thursday of the month is specifically focusing on answer writing. Answer writing in the sense, there are important issues which occur in the country or in the international world relevant for your examination. But how do you answer the main specific questions that are asked from these current affairs developments in your examination? How do you master the art of answer writing? Because my dear, mains is all about answer writing. In prelims examination, there is a question given to you and then there are 4 options. All you have to do, pick the right answer or pick the most appropriate answer. But when it comes to the mains examination, you will have to write your answer, descriptive answer, in 100 words, 150 words, 250 words, depending upon what the UPSC is asking you. So you will have to write your answer. And that becomes challenging because that's an art that you will have to learn. What does that mean? For example, today, if I ask you to write an answer on constitutionalism, for example, a concept that we will study today, constitutionalism, maybe you will not be in a position to answer that question. Write even 50 words on this topic. But once you're attending these classes on a regular basis, once the polity batch is over, you will be able to write 4, 5, 6 pages on this concept called constitutionalism. But there lies the challenge. The challenge is UPSC tells you answer should not be more than 250 words. Or answer should not be more than 150 words. So you have a lot of knowledge now. Now what you have to do, you have to restrict it and write an answer in less than 250 words. So you should know what to include, what to exclude. You should know whether the answer should be in paragraphs or in point format. You should know whether some politically controversial statements can be written in the examination or not. You should know whether you can name important political leaders in your answers. You should know whether your personal political bias should be reflected in your answers or not. That is an art that you will have to learn. And that is why our 4th webinar of a Thursday of a month is dedicated to writing answers on current affairs topics relevant for your mains examination. And then the most important thing, 2 things, knowledge and application. First and foremost, your idea should be to gather and gain knowledge and information. Because unless and until you gain knowledge and information on all the subjects that are mentioned in your syllabus, on all the topics that are relevant for your examination, but that is only one part. Then you will have to apply your knowledge as well. Apply in the sense because you are preparing for a competitive exam. You have to do well, but you have to do better than others because this is a competition. And in this competition, you have to defeat others as well, whether good or bad, but this is a competition after all. So there lies the challenge. Whether you are able to prepare for the prelims exam, whether you are on the right track when it comes to the prelims exam, whether you are on the right track when it comes to the mains examination. For that, practice is the key. And that is why we have weekly tests. What are these weekly tests? For example, Monday to Friday, in a morning batch, in Indian Polity, all the concepts and topics that we will discuss, we will study. On a Saturday, we will have 20 MCQs in the form of a weekly test. You will have to answer those questions. These questions will be available on the app. So whatever concepts, topics we will study in a week, that forms the basis of your weekly test. And 20 questions will be asked, 20 MCQs will be asked from the topics that we are covering in a week, so that you are preparing for the prelims examination, so that you're ready for the prelims examination. But what about mains examination? Same topics and concepts that we study in a week. That forms the basis of the 5 descriptive questions that we give you on a Saturday, which will help you prepare and ace the mains examination. So please take these weekly tests seriously. I beseech you, I urge you, please take these tests seriously, because you are gaining knowledge. But unless and until you are gaining knowledge required for this examination, it becomes irrelevant. You have to gain knowledge, but then you'll have to also ace the examination. You have to gain only that much knowledge which will help you ace the prelims and the main stage. For that, please take these weekly tests seriously. Once you start, you may not be able to write a good answer. You may not be able to write a beautiful answer, but then you'll have to start. Once you learn over a period of time, you will master this art of answer writing, and that is the time, that's the day when you are ready for the mains examination. So don't give me this excuse that, sir, I don't know how to write an answer. I have understood your classes, but I don't know how to structure my answer. You would not know that right at the beginning, but then practice. And practice, 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 that is going to help you in your mains exam, because it is important to make mistakes now rather than making mistakes in the real examination. I'll give you an analogy. For example, you have to learn the art of driving. You have to drive a vehicle. You have to drive a car. Once you start, it becomes difficult for you to drive the car smoothly. For example, the instructor next to you will guide you. This is accelerator, this is brake, this is clutch, assuming it's not an automatic car. This is the indicator, this is the wiper, this is the dipper, turn left, turn right, don't do this, don't lift your feet from the pedal instantly, otherwise the car will stop. And you realize in your first, second, third, fourth, or fifth interaction that you will never be in a position to drive this car on a highway because it is too difficult for me. But what do? You practice, you learn, and over a period of time, you become an expert. You're zooming past on a highway, overtaking the irritating tippers as well. That's the art of learning. So initially, it will be difficult for you to write a good answer, to write a cogent answer, to write a brilliant, beautiful answer. But please practice. Share your answers with us. We shall evaluate, and we will tell you exactly what you should have written, what you should not have written, how you should have structured your answer. Because unless and until you know how to put your knowledge across and convince the examiner that you know everything about the topic that you are asking, about the question that you're asking, it becomes irrelevant then, right? So what do? You have some expectations from us, and you should have some expectations from yourself as well. We will give you classes, and to the best of our capability and ability, we will ensure that we will give you the best standard lectures. Best standard lectures in this country, so that you're able to understand these topics brilliantly. Then an additional reading material, annotated PPTs, books. This forms the basis of your content. And then you'll have to apply it in the form of weekly tests, which will be focused on prelims as well as mains. And then over a period of time, when the time comes, we launch the prelims test series and then the mains test series. Prelims test series and mains test series, where you will be competing with 50,000 other aspirants. And then you will decide, and then you will realize where exactly do you stand in this examination. That is what we provide. And at any point in time, if you have a doubt, please reach out to the mentors via the mentor helpline. These are experts. They will resolve your doubts to the best of their capability so that we leave no stone unturned, as the cliche goes, and we will help you ace the examination. If you have any questions on this, please let me know. I'll give you 5 minutes. All the questions, any questions that you have on whatever we have discussed as of now, shoot your questions. I'll be more than happy to answer. Then we will formally start Indian Polity. Questions, please. Gumnam, how to make timetable? My dear, this is the timetable for you. This should be the basis of your timetable. So if you're attending the class in the morning, 6 to 9:30, now it also depends on what is the extra thing that you do, whether you're working somewhere or you're preparing for this exam full time. And that is where the strategy would also differ. If you are preparing for this exam full time, once you have attended this class 6 to 9:30, all you have to do, revise it, watch our Hindu newspaper analysis on YouTube. That will cover your current affairs. Revise whatever we have studied in the morning. Then focus upon your optional for 2.5 hours. That should be your timetable for the day. Which means, for example, this is the morning batch timetable. If you are attending these classes regularly and are attentive in the class, once we complete polity, and you have also revised polity after the class, after each class, which means on one hand, we are covering polity, completing polity, and on the other hand, you are also revising polity. Problem solved. Similarly, next time, after the polity, we'll have economics. So study economics, and at the same time, once the class is over, every day once the class is over, revise the same topics that are covered in the class. So on one hand, the syllabus is complete. On the other hand, your revision is also done. Your first revision is also done. And you have to keep in mind that you have to revise at least 5 to 7 times. At least 5 to 7 times revision. Because if you're reading a concept once, it is as good as if you have never read that concept. You have to read it, revise it multiple times. That's when it gets ingrained into your mind. Sir, after Byju's guidance, do we need other guidance from outside like notes, magazines? We provide current affairs monthly magazine as well. So you don't need anything else. If you can please stick to one source, because the problem is, my dear, when you start, so today you will ask me these questions. Sir, for polity, should I follow your notes, additional reading material, annotated PPTs, M. Laxmikanth, D.D. Basu, Subhash Kashyap, V.N. Shukla, IndianQanun.org, PRS, Hindu, and Indian Express? Will it help me clear all the prelims questions, mains questions from Indian Polity? I'll say yes. After a few months, you'll come back again. Sir, your class notes, Laxmikanth, Indian Express, and D.D. Basu, would that be sufficient? I want to skip other sources. I would again say yes. Closer to the examination, sir, only Laxmikanth and your notes. Will that be sufficient? I would say yes. So don't proliferate your sources. Keep your sources minimum. One book per subject. One source per subject. Whatever the source is, just keep one source. Keep revising it. And ultimately, that's going to be beneficial and fruitful for you. Please don't follow multiple sources on a single subject, or multiple current affairs magazines from different coaching institutes. There is nothing different in any of the other current affairs magazines. Everything is the same. When classes are going on, do I make notes as well? Yes. Whatever we discuss, make notes of it, make the running notes of this. That's going to be very helpful for your revision. In any case, we will give you annotated PPTs as well, but I would urge my students to make running notes of whatever we discuss in the class. I don't have book from Byju's. I have my own book, Laxmikanth. We also give the same Laxmikanth, my dear. So Mr. Laxmikanth has not written something unique in the Byju's book, which is not there in any other, in the regular Laxmikanth book. That book is the same. So follow any Laxmikanth. Okay. Now let's look at and formally start our CSE 2024 batch. We'll start with Indian Polity. Indian Polity, my dear, relevant for prelims, relevant for mains, relevant for your personality test as well. And now listen to me carefully. Indian Polity, we say, is one of the most important subjects for the civil services examination. But why do I say it's one of the most important subjects? Not because I teach the subject, but look at the relevance of this exam, or look at the relevance of the subject in all the stages of this examination. When it comes to the prelims examination, look at the trend. From 2011 till 2022, sometimes 10 questions, sometimes 15, sometimes 17, sometimes 22 questions have been asked from Indian Polity. Prelims GS, you would know, is of 200 marks. Clear? And the cutoff varies. Sometimes the cutoff is 95, sometimes the cutoff is 87, sometimes the cutoff can be 100. Let's assume on an average, the cutoff is 100. So you have to score 100 in your GS paper 1 prelims exam. And if you cross the cutoff, then you're eligible to write the mains examination. That much you know. If from Indian Polity alone, 22 questions are asked, which means 44 marks. 44 marks, and I will ensure that we teach this subject in such a beautiful manner that you will be able to solve every question that comes in the prelims examination. Now, prelims is a very important subject. It's also a scoring subject as well. And at the same time, it has the best weightage when it comes to the examination. In a sense, sometimes 15, sometimes 17, sometimes 18, sometimes 20, sometimes 22 questions are asked from Indian Polity. Considering the fact that the cutoff can be 100, for example, if 44 marks you can easily score from Indian Polity, isn't Indian Polity the most important subject or one of the most important subject for your examination? Yes. So when I say Indian Polity is one of the most important subjects, I specifically look at this from the perspective of its relevance for this examination. Relevant for prelims because 22 questions every year are asked from Indian Polity. Look at the mains examination and listen to me carefully. When you look at mains GS paper 2, it deals with polity, it deals with governance, it deals with social justice, it deals with international relations. So GS paper 2 for mains examination deals with polity, governance, social justice, international relations. Today and for the next 23 classes, we will be focusing on polity. Because for governance, there is a separate discussion altogether, separate course altogether. Course in the sense, separate time we will discuss, we will cover governance. So governance is scheduled, for example, ethics and governance from 19th June to 21st July, we will cover ethics and governance together. So governance we will study separately. Social justice, social issues, social justice, essay and disaster management, we will study separately. So in these 24 classes, our focus will be on polity. But GS paper 2 deals with polity, it deals with governance, it deals with social justice, it deals with international relations. International relations also will be discussed and taught separately. Only the polity, what is its relevance for the mains exam? Sometimes 75 questions, 75 marks, sometimes 120, and in 2022, 150 marks worth questions were asked from polity. That is why I say Indian polity is one of the most important subjects when it comes to the civil services examination. Important in the sense, it is important for your prelims exam. Without having the solid control and solid expertise over polity, it becomes difficult, almost impossible to clear the prelims exam. Because 44 marks or even 30 marks, and you can easily score marks in polity. It's a very easy subject, and I'll make it even more easier. Very scoring subject, very important subject. That's why we say it's important. But when it comes to the mains exam, sometimes 150 marks. Every GS paper carries 250 marks. If 150 marks are asked from Indian polity, isn't polity the most important subject for the civil services examination? And your knowledge in Indian polity will help you in your essay as well, and will help you in your personality test as well. For example, essays you're writing, your knowledge of polity, constitution, laws passed by the parliament, verdicts given by the Honorable Supreme Court, it will help you write a better essay. So polity becomes a subject which is relevant for your prelims, as well as GS paper 2, as well as essay. And in every personality test, a large set of questions are asked from polity. In a sense, the question can be, for example, yesterday I was having an interaction with a student who is appearing in the personality test. What are the type of questions asked? What is your take on the remote electronic voting machine, which is now the new idea for the Election Commission of India, where remotely the migrants will be allowed to vote without having to travel to their respective states, the state where they are working, the state where they are residing, they can vote there. What's your take on this? What is your take on the current tussle between the executive and the judiciary over judicial appointments? Ideally, how should the judges be appointed? Should there be a role of executive? Should there be a role of the government in appointing the judges? So personality test also, a large set of questions are asked from Indian polity. That is why I say Indian polity is one of the most important subjects. Why? Because it's relevant for prelims, relevant for GS paper 2 mains, relevant for essay, relevant for personality test. So Indian polity is relevant for all the stages of your examination. Clear? So what are we going to discuss in these 24 classes? We will be focusing on Indian polity. We will not focus on governance because that will be taught separately. We will not focus on social justice, that will be taught separately. We will not focus on IR, international relations, because that will be taught separately. We will specifically focus on Indian polity, both from prelims as well as the mains perspective. Now listen to me carefully. You don't have to prepare for prelims first and then prepare for mains. You have to prepare for prelims as well as mains simultaneously. So in these 24 classes, we will complete Indian polity, but we will complete it completely from the prelims as well as the mains perspective. Clear? Done? If Indian polity is the most important subject for the civil services examination, but the fundamental question that you should be asking me, what you should ask yourself is exactly what do we have to study in Indian polity? What exactly do we have to cover in this important subject? Basically, three things. Number one, the Constitution of India. Constitution of India starts with preamble, then union and its territory, then citizenship, then fundamental rights, then directive principles of state policy, then fundamental duties, then union, states, union territories, panchayati raj institutions, elections, judiciary, everything. So constitution is first thing that we have to focus on when it comes to Indian polity. But listen to me carefully. Constitution is to be studied by law graduates as well. Constitution is to be studied by those who have law as the optional for the civil services exam. Constitution is to be studied by our politicians as well. And Constitution is to be studied by the civil services aspirants as well. But civil services is basically a generalist exam. Generalist exam in the sense, it is not a specialist exam, it's a generalist exam. What is the difference? An aspirant preparing for the civil services exam, listen to me carefully, because this is where the students, they get confused and they don't know exactly what is required for this examination. Because once you know what is the exact requirement of this exam, then there is no power on earth that can stop you from clearing this examination. But you should know what to expect in the examination. This is a generalist civil service, which means an aspirant preparing for this exam should know polity as well, geography as well, economics as well, international relations as well, history as well, art and culture, ancient, medieval, world history, post-independent India, ethics, disaster management. Now, is it possible for one individual, with hand on your heart, tell me, is it possible for an individual to be expert in polity, economics, geography, history, disaster management, in all these subjects? No. UPSC also knows this. So UPSC is not expecting that these aspirants who are preparing for this exam, they will be experts in all these subjects, because it is not possible. When it is not possible, that cannot be the expectation either. So you don't have to be an expert on Indian Constitution. You don't have to be an expert. You should know the provisions of the Indian Constitution relevant for the civil services exam. But how do we know what is relevant for the civil services exam? For that, there is one document that you must repeatedly go through. And that is previous year's question papers. Syllabus tells you what to study. Previous year's question papers will tell you how to study. So the question on Indian polity from Indian Constitution, what type of questions have been asked? For that, please go through previous year's question papers, both prelims as well as mains examination. And you will realize that you don't have to be an expert. You just need good, solid, brief outline about Indian Constitution. That is all that is required for you to ace the examination. So you don't have to read the entire Constitution. You have to read those portions which are relevant for this examination. And how do you know what portion is relevant and to what extent we have to cover these portions? That's why you have joined us. That's something that I'm going to tell you. In all these classes, we will explain Indian Constitution strictly from the point of civil services exam. Which means by attending these classes, you may win a debate competition in your college or a university. I get these mails from the students, sir, thanks to you, I won prize 1 in a debate contest. I won prize 2 in another contest. But that is only a byproduct. By attending these lectures, you may win an argument with your friends. So your friends are discussing the political developments. EVMs can be hacked. That is why a political party is winning the election. But you can say, no, EVMs cannot be hacked. I know EVMs are standalone machines. They're not connected to the internet, which means they cannot be remotely operated, which means EVMs cannot be hacked. So your friend would be surprised. How do you know all this? I know, because I'm a well-informed citizen of this country, because you're not telling him that you're also preparing for the civil services exam. But that is a byproduct. By attending these lectures, you may win a debate contest in your college or a university. You may win an argument and impress your friends. You may win an argument with an irritating uncle in your neighborhood, but that's only a byproduct. You have to study as much Indian polity as will help you ace the examination. Nothing more, nothing less. So strictly keep your mind aligned with the requirement of this examination. Don't deviate. When I say don't deviate, I'm telling you from my experience. After guiding students for the past decade, there are students who get so involved in Indian polity that they start neglecting all other subjects. They are studying only Indian polity and becoming experts in Indian polity. Irrelevant, my dear. It's a beautiful subject, but then you don't have to neglect other subjects. Because unless and until you have good understanding of all the subjects of this examination, you cannot clear this examination. That is why you don't have to discriminate. You have to give attention to each and every subject. But for Indian polity, what is it that you have to study? 3 things. Number 1, the Constitution of India, but not the entire Constitution in great detail and great depths as someone from a law university would do. No. But Constitution strictly from the civil services examination point of view. And how do you know that? That's why you have joined us. I'm going to tell you. Second, the laws passed by the legislature. For example, a law was passed by the parliament known as Citizenship Amendment Act 2019. We'll have to read that. A law was passed by the parliament, Aadhaar. We'll have to read that. A law was passed by the parliament known as Child Labor Abolition Act. We'll have to read that. So Indian polity, number 1, it's one of the most important subjects for the civil services examination. And when we say important, how can we judge the importance of the subject? Because Indian polity is relevant for prelims, GS paper 2 mains, essay, as well as the personality test. Which means in all the stages of this examination, Indian polity is relevant. That is why it is important. Okay, we understood that it is very important. Otherwise, we would not be studying Indian polity. So Indian polity is important. But now please tell us, what is it that we have to study in Indian polity? My dear, 3 things. 1, the Constitution of India. Number 2, the laws passed by the legislature. Legislature means a body which is responsible for making laws. Now, which is the body which is responsible for making laws? At the central level, we have the parliament, the temple of India's democracy, Lok Sabha, Rajya Sabha. In the states, we have the state legislative assemblies. These are what we call legislatures. So laws passed by the legislature becomes important for your examination. So does that mean, another question on your mind, so does that mean we have to study the laws passed by the Indian Parliament as well as the laws passed by the state legislatures? That's something that we have to study as well. Mostly, predominantly, we'll have to study the laws passed by the Parliament of India, the central legislature. But then there are some laws passed by the state legislatures as well. If they have an impact on the entire country, then we have to study those laws. How? For example, there are some states which have passed laws which are popularly or notoriously known as the love jihad laws. We'll have to discuss them as well because it has a pan-India significance. There are some states which have decided that we will implement something known as the Uniform Civil Code. I know these terms are Greek to you right now. You don't know what these terms are all about, but you will understand this one by one, slowly and steadily. Don't panic, don't rush. So there are some states which are trying to implement something called as the Uniform Civil Code. That will have a pan-India impact. We'll have to study those laws as well. So Indian polity, first, we have to study the Constitution of India, then laws passed by the legislature, mostly the laws passed by the central parliament, but those laws passed by the state legislatures, which have a wider implication, which have a wider resonance in the country, we'll have to study those as well. And then judicial verdicts. Supreme Court says demonetization is legal. We'll have to discuss. Supreme Court says EWS reservation, providing reservation, 10% reservation in government jobs, 10% reservation in educational institutions for those belonging to the economically weaker sections of the society. Supreme Court says this reservation is constitutional. We have to discuss that as well. Or right now, hot news, where newspapers, media is dominated by this judgment of the court, Keshavananda Bharati versus State of Kerala, way back in 1973. But it has resonance even today. That is when the Supreme Court propounded a doctrine known as the basic structure. What is that basic structure? What is that Keshavananda Bharati judgment? We have to discuss that as well. So long story short, Indian polity is important subject. Sir, we know that. Now we have understood. What exactly do we have to study in Indian polity? Three things. One, the Constitution of India. Second, laws passed by the legislature, mostly the central parliament, but some of the states as well. And third, important judicial verdicts, important judgments, pronouncements of the Honorable Supreme Court. That is something that we will have to study as well. So what about high courts? Same. Those high court judgments which have wider implication, we'll have to discuss those as well. All these three things put together, that is going to be our focus when it comes to Indian polity. Any questions as of now? Please shoot your questions. I'll give you 2 minutes and then we will formally start Indian polity. Got it. In weekend batch, polity will be done by you? No, my dear. I'll be teaching in the morning batch. Clear. Okay. Sir, I am at a point where I don't know what legislature means. Please don't worry. We'll start the class assuming that you know nothing about this exam. Assuming you don't know anything that is happening in the country. I'll assume all of you are engineers who study one day before the examination. Don't worry, everything would be clear. Okay. Now, if polity is important, if this is something that we have to study in Indian polity, these are the three areas. But exactly what should we follow? What sources should we follow for Indian polity? For that, there are lots of sources available in the market. There is a book by Mr. M. Laxmikanth, D.D. Basu, Subhash Kashyap, V.N. Shukla. Then there are websites such as PRS Legislative Research, IndianQanun.org. Then we have newspapers such as the Hindu, the Indian Express. Then we have various other portals as well. Sir, what exactly should we follow for Indian polity? If you're attending these classes regularly, attend the classes. Second, make running notes of whatever we discuss in the class. Take a look at the annotated PPTs. M. Laxmikanth. Newspaper. These are the sources that you have to follow. Forget about D.D. Basu. Forget about other books. Forget about other websites. Don't follow anything. If you have time, you can follow these two NCERTs. Class 11th NCERTs, Political Theory and Indian Constitution at Work. If you have time, you can follow these two NCERTs. If you don't have time, don't worry. I would ensure that my classes would have content from NCERTs, Subhash Kashyap, V.N. Shukla, IndianQanun.org, PRS Legislative Research, from various other documents, from various other books. There are some brilliant books that are to be studied by the teachers, but not by the students. So I will ensure that my classes would cover all the important sources. But at the end of the day, you have to take a look at the annotated PPTs, make running notes of whatever we have discussed in the class, and all the topics that we discussed today. Let's say, for example, today we discuss preamble. For example, once the class is over, read preamble from Laxmikanth. Similarly, if today we discuss the office of governor, Once the class is over, read the Office of Governor chapter from M. Laxmikanth. So whatever we study in the class, read the same portions from Laxmikanth. That's it. Plus a national newspaper, which can be the Hindu, which can be the Indian Express. Now, sir, do I follow Hindu or Indian Express? Both are equally good newspapers. Sir, I like Indian Express better. Read it. Sir, I like the Hindu better. Read it. Read any of these two national newspapers. Sir, I like Times of India better. I know why you like Times of India better, but don't read it. It's a masala newspaper. The Times of India would tell you by reading Times of India, you will understand what is the nickname of Hrithik Roshan, but you may not understand what is Keshavaranda Bharati verdict. So you have to look at a newspaper which is relevant for your civil services exam, which is best aligned with your preparation. For that, choose between the Hindu or the Indian Express. Both are equally good. If you want to choose one, which can be the Hindu or Indian Express. Clear? Plus, every week on Saturday, 8 p.m. onwards, I take a session on YouTube, Polity This Week, where even if you are not reading newspapers regularly, but I will cover all the important polity-based current affairs and we will discuss it once a week on Saturday, 8 p.m. onwards. That's something that you can follow for current affairs as well. Clear? So don't read multiple books. Laxmikanth is the worst book written on Indian polity. Sir, can you say it again? It's the worst book written on Indian polity. It has absolutely no sense. It doesn't explain you concepts. It doesn't give you the background information. It's just basically a copy-paste material. But it is relevant for your prelims exam. It is not relevant for your mains. It is not going to help you in your mains examination. But for mains examination, so then what do we follow? My notes, Laxmikanth plus current affairs. Current affairs is the key. Current affairs plus the class notes or the classes material, annotated PPTs, plus M. Laxmikanth. These are the three things that you have to follow when it comes to the Indian polity. So Indian polity is important. Yes, sir. Understood. These are the three things that we have to study in Indian polity. Understood. What are the sources? If you have time, read these two very beautiful books, NCRT books, Political Theory and Our Constitution at Work, Class 11th NCRTs. If you don't have time, don't worry. We will cover it in the classes. Then, what is it that you have to follow? My classes. Attend regularly, religiously, ask thousands of doubts that you have. We'll be more than happy to help. If we can't resolve these doubts, for example, some of the doubts I will resolve by taking these questions. Some of the doubts you can ask subject matter experts who are now part of this class. You can ask them and they will answer. Some of the doubts you can send me a mail. I will reply to the mail. Some of the doubts you can check with your mentor. Get in touch with your mentor and they will help you resolve your doubts. What is my email ID? There's a dot here. I will reply for sure, but I may be late in replying. You may expect a delayed reply, but I will reply for sure. Clear? Done? 100%? Let's look at, and let me tell you the third time, let's formally start Indian polity. Because if constitution is something that we have to study for the civil services exam, we should first have an understanding of what is a constitution. So what is a constitution basically? We say constitution is a supreme law of land And the supreme law of land enjoys special legal sanctity. What do we mean by that? Let's say, for example, if we look at a hierarchy, at the top of the hierarchy, we have the Constitution of India. Followed by that, we have the laws passed by the legislature. Followed by rules issued by the executive. What does that mean? Legislature is Parliament of India, a body which is responsible for making laws. Clear? What is executive? Prime Minister, ministers at the central government, President of India, they are part of the executive. Similarly, at the state level, we have the State Legislative Assembly, which is a legislature which is making laws. Similarly, we have the executive, governor, chief minister, ministers. Now, what is the job of the executive? Job of the executive is to implement the laws. Job of the legislature is to make laws. For example, we have a law passed by the parliament, and that law is, let's say, for example, Citizenship Amendment Act. This law was passed in the year 2019. According to this law, if you are migrated from Pakistan, Afghanistan, Bangladesh on or before 31st December 2014, you are not an illegal migrant, which means we will give you citizenship. Very briefly, we will discuss CAA in great detail when we will discuss citizenship. But here the idea is to tell you what is the difference between the legislature and the executive, and why we say Constitution is the supreme law of land. I say Constitution is the supreme law of land because if at all there is a hierarchy, at the top of the hierarchy we have the Constitution. Then we have the laws passed by the parliament. Then we have the rules issued by the executive. For example, we have the Constitution. Then we have Citizenship Amendment Act, which is the law passed by the parliament, which says if you have migrated from Pakistan, Afghanistan, Bangladesh, and you have entered India on or before 31st December 2014, on 31st December 2014 or before 31st December 2014, if you have entered India, we will give you citizenship. We will not treat you illegal migrants because illegal migrants are not eligible for citizenship. Now, who is an illegal migrant? For example, I am from Bangladesh. I have to enter India. What are the ways of entering India? I have to go to the Indian embassy in Bangladesh. I have to ask for visa. Once visa is given, on this travel document, I can enter India. That means I am a legal migrant to India. I am from Bangladesh. I have entered India, but legally because of this visa document. Now, for example, this visa was valid for 1 month. For 1 month, I stayed in India, but now I am overstaying. In a sense, I'm staying for 2 months or 3 months or 4 months. I become an illegal migrant, which means I am from Bangladesh. I entered India, but I'm not a legal migrant. I'm an illegal migrant because I'm overstaying. Because the visa said you should have stayed for 1 month. I am now staying for 3rd month, 4th month, 5th month. I'm an illegal migrant. Illegal migrant can be someone else as well. Even without getting a visa, you may sneak through the border of India, Bangladesh, and you may enter India illegally, even without this visa document. Then who are you? You are illegal migrant. Because in India, can foreigners become citizens of India? Yes, they can. For example, Srimati Sonia Gandhi, she was a foreigner. She was born in Italy. She was an Italian. But she came to India. She stayed legally in India. She married an Indian. After some time, you can apply for citizenship. She applied for citizenship. She became an Indian. Adnan Sami, basically a Pakistani. Then he went to Canada, but now he's an Indian citizen. That means foreigners are allowed to become Indian citizens provided they meet some criteria. And what is that criteria? We will discuss that in citizenship. Here the point is CAA 2019. It says if you are from Pakistan, Afghanistan, Bangladesh, and you have come to India, but basically these people came to India because they feared for their lives, because they were persecuted, they were assaulted, they were killed, they were tortured in Pakistan, Afghanistan, and Bangladesh. So they fled these countries. Now, when you are fleeing a country, you cannot ask for visa, you cannot ask for passport. So basically, they are running away from Pakistan, Afghanistan, and Bangladesh to save their lives. So they have entered India illegally. But this law, CAA 2019, it says if you have come from Pakistan, Afghanistan, Bangladesh, and we are basically assuming you basically came to India to save your lives. And if you are from Hindus, Sikhs, Christians, Buddhists, Jains, Parsis, if you are from these 6 religious minorities from 3 Islamic countries, you can come to India. We will not call you illegal migrants, which means illegal migrants were not eligible for citizenship, but you will be eligible for citizenship. That is CAA 2019. That is the law passed by the parliament, which basically means at the top of the hierarchy, we have the Constitution of India, then we have the laws passed by the parliament, then we have the rules issued by the executive. Which are these rules? For example, to implement this law, we need some rules. What are these rules? Parliament cannot pass a full-fledged law. Full-fledged law, in a sense, a complete law, a total law. Why? Because Parliament can pass a law in a skeleton format. Skeleton in the sense, it will give you broad points. If you have come to India from Pakistan, Afghanistan, Bangladesh, on or before 31st December 2014, you are not an illegal migrant, you are eligible for citizenship. Clear? This is the law. But how do we implement this law? For that, rules are to be made. Which are these rules? For example, how would we know that this particular gentleman has come from Pakistan, Afghanistan, and Bangladesh? How would we know that this particular gentleman has come to India on or before 31st December 2014? How do we know that this particular gentleman belongs to Hindus, Christians, Buddhists, Jains, Parsis, or Sikhs? How do we know? For that, rules will be made by the executive. So Home Ministry, Mr. Amit Shah's department, the bureaucrats you're all aspiring for to become a bureaucrat, you will make rules to implement this law. So when it comes to Constitution, we say Constitution is the supreme law of land. That means at the top of the hierarchy, we have the Constitution of India. Then we have the laws passed by the Parliament. Then we have the rules issued by the executive. Clear? But sir, why can't we add all the laws to the Constitution? Why are there some provisions mentioned in the Constitution, but then there are other laws passed by the Parliament which are not mentioned in the Constitution? Why can't we have every law mentioned in the Constitution? We can't. Why? To change the Constitution, we need a tougher majority. It becomes difficult to change the Constitution. Tougher majority in the sense, we will discuss it today if we have time. To amend the Constitution. Amend the Constitution means to change something in the Constitution, to add something to the Constitution, to delete something from the Constitution, to add some provisions to the Constitution. You require majority in the Parliament. Parliament majority in the sense, all the members in Lok Sabha, 2/3 of them should support it. All the members in Rajya Sabha, 2/3 of them should support it. Which means if you want to add something to the Constitution, that means you're amending the Constitution, you're changing the Constitution, 2/3 of the members in Lok Sabha should agree to this. 2/3 of the members of Rajya Sabha should agree to this. Unless and until they agree, you can't add this law to the Constitution. That is why we have changed Constitution, amended Constitution only 105 times since 1950. when the constitution was enacted. We have made changes to the constitution only 105 times, but we have passed hundreds of other laws. Because if every law is placed in the constitution, then it becomes difficult to change it, alter it. But the laws may require periodic changes. Laws may require repeated changes. Those things which change over a period of time, which repeatedly can change over a period of time, for that we pass a law. Everything else which is required for a larger point in time, which is required forever and ever, we add that to the constitution. Long story short, what is a constitution? We say constitution is the supreme law of land. What is that supreme law of land? If there is a hierarchy, if in India we have the constitution, we have the laws passed by the parliament, we have the rules issued by the executive, if we have to give them a hierarchy, at the top of the hierarchy is the constitution. Then we have the laws passed by the parliament. Then we have the rules issued by the executive. But constitution is the supreme law of land which enjoys special legal sanctity. Sanctity in the sense, can this rule issued by the executive violate the constitution? No. Can a law passed by the parliament violate the constitution? No. That means any law passed by the parliament, any rule issued by the executive has to be in agreement with the constitution. If any law passed by the parliament violates the constitution, that law is unconstitutional. If any rule passed by the executive violates the spirit of the constitution, that rule will be declared unconstitutional. Sir, can you give an example? I'll give an example. Recent example, Section 66 capital A of Information Technology Act, the year was 2000. And this section was added in the year 2008. What does that mean? In the year 2000, a law was passed by the parliament. What was that law? Information Technology Act 2000. Clear? This law was amended in the year 2008. Section 66 capital A was added to this law. What did this Section 66 capital A say? If you are using an electronic device, electronic device can be a smartphone, a laptop, a desktop. If you're using an electronic device and through this electronic device you transmit a message which may cause annoyance to somebody, you are basically committing a crime. Section 66 capital A, which was added to the Information Technology Act in the year 2008. The law was passed in 2000, but it was amended in the year 2008 to add Section 66 capital A. What did this law say? It said if you are using a computer device, an electronic device, and you transmit a message, and this message can cause annoyance to somebody, you have committed a crime. This was Section 66 capital A. Now, sometime later, Shiv Sena Supremo, Mr. Bal Thackeray, he passed away. And then the members of the Shiv Sena, they organized a bandh, organized a procession, and basically asked, and some of them say basically forced shopkeepers to lower your shutters. Nobody should work. Let's organize a bandh in Maharashtra. One lady, Shaheen Darda, she wrote on her Facebook, what is the need to organize a bandh if Bal Thackeray has passed away, if Shri Balasaheb Thackeray has died? One of her friends liked her status. Both were arrested under Section 66 capital A of Information Technology Act. Why? Because they were using an electronic device to transmit a message, which can be a Facebook post, which can be a tweet, and it can cause annoyance to somebody. This Facebook post caused annoyance to the members of the Shiv Sena, and basically Shaheen Darda and her friend were arrested. In another case, a businessman from Puducherry, he had tweeted something against Karti Chidambaram. Karti Chidambaram is the son of Mr. P. Chidambaram. Mr. P. Chidambaram then was the finance minister. So this gentleman, this businessman from Puducherry, tweeted something which caused annoyance to Karti Chidambaram, and this businessman was arrested. One law student, Shreya Singhal, she approached the Supreme Court. Shreya Singhal approached the Supreme Court and asked the Supreme Court a question. Dear Supreme Court, this Section 66 capital A, which is a law passed by the legislature, it violates the Constitution. The court asked, what provision of the Constitution? Shreya Singhal said, Article 19(1)A of the Constitution. What is Article 19(1)A? Freedom of speech and expression. Constitution, under Article 19(1)A of the Constitution, gives me a fundamental right to free speech. I can say whatever I have to say. I can express whatever I have to express. This Section 66A, which says if you transmit a message which causes annoyance to somebody, isn't truth always annoying to somebody? I'm just expressing my feeling that what is the need to organize a bandh? On this ground, why should I be arrested? Does this not violate my fundamental right to freedom of speech and expression? Supreme Court said, you're absolutely right. This Section 66A violates the fundamental right to freedom of speech and expression, which is mentioned in the Constitution. Therefore, this Section 66A is unconstitutional. Unconstitutional in the sense, now nobody can be arrested under Section 66 capital A. It is not a crime. So can a law passed by the Parliament violate the Constitution? No. Can a rule issued by the executive violate the Constitution? No. Can Constitution violate a law passed by the Parliament? Yes. Can Constitution violate a rule issued by the executive? Yes. Constitution is supreme. Constitution is the supreme law of land, which means at the top of the hierarchy we have the Constitution. And this supreme law of land enjoys special legal sanctity, which means neither the law passed by the Parliament nor the rule issued by the executive can violate the Constitution. So the first definition of the Constitution is the supreme law of land which enjoys special legal sanctity. Not just this. When we say Constitution, legislature will make laws. Where is it mentioned? Constitution. Executive will implement these laws. Where is it mentioned? Constitution. Judiciary will give justice. Where is it mentioned? Constitution. So what is Constitution then? Constitution is then a rule book. What is Constitution then? It's a rule book which allocates roles and responsibilities to different organs of the state. What are the different organs of the state? We have legislature. we have executive, we have judiciary. What should be the role of the legislature mentioned in the Constitution? What should be the role of the executive mentioned in the Constitution? What should be the role of the judiciary, the Supreme Court and high courts mentioned in the Constitution? So Constitution number 1 is the supreme law of land which enjoys special legal sanctity. But Constitution is also the supreme rule book, allocating roles and responsibilities to the different organs of the state. What is the role to be played by different organs such as legislature, executive, judiciary? That is the Constitution. But Constitution is something else as well. Prior to India getting its own constitution, prior to India becoming an independent, we were governed by the laws passed by the British, because we were a colony of the British. It was the British Parliament which was passing laws for the people of this country. That's how Government of India Act 1858 was passed. Indian Councils Act 1861 was passed. Indian Councils Act were passed. We will discuss all these acts in modern history. So modern history, where we will talk about developments in India. So we will discuss the developments from, let's say, 1707, because modern history is considered to be the period which starts after the death of Aurangzeb in 1707. So 1707, then came those later Mughals, then came British, there were Dutch, French, British who came to India, then how British consolidated power in India, then how British Parliament passed various laws to strengthen its control over India. All that will be discussed in modern history. But here, what do we have to keep in mind? Prior to India's independence, we had some expectations. People always have some expectations. We also had some expectations. We wanted justice. We wanted liberty. We wanted freedom of speech and expression. But we were not given. Why? Because the law was passed by the British Parliament and we were a colony. So there were some expectations that people had in India, but those expectations were never met because we were a colony. But once India got independence, then we have something known as, or we had something known as the Constituent Assembly. What is Constituent Assembly? Because in 1946, when Britain said, yes, India can be independent, we will give India independence. But for that, how India will be governed? What sort of democracy will India have? Will President have all the powers, or Prime Minister will have all the powers? What will be the role of the Election Commission of India? How should the finances, how should the revenue between the center and the states be distributed? Basically, long story short, how should the administration of this entire country be governed? For that, we need a rule book, and that rule book is Constitution. So if India has to become independent, how India will govern itself, for that there should be a rule book known as the Constitution. And this Constitution, who will frame? Members of India, people of India. And then a body was set up known as Constituent Assembly, which met for the first time on 9th of December 1946. Constituent Assembly, some representatives of the people of India, they were part of this Constituent Assembly, which means people of India, some of them represented in this Constituent Assembly. Now this Constituent Assembly had the responsibility to frame the Constitution, to draft the Constitution, to draft this rule book. And these members of the Constituent Assembly, because they were Indians, they realized what are the expectations of the people. So our expectation is treat us equally. Our expectation is give us justice. Our expectation is give us freedom of speech and expression. Our aspiration is give us liberty. All those aspirations were beautifully documented by the members of the Constituent Assembly in framing this constitution. So constitution is a reflection of people's faith and aspirations. So what is constitution? Constitution, number one, it's the supreme law of land which enjoys special legal sanctity. Constitution is a document of people's faith and aspirations. Constitution is a rule book which allocates responsibility, roles and responsibilities to different organs of the state. Constitution, basically, the vast majority of contemporary constitutions describe the basic principles of the state. Principles of the state. Are we going to be a secular country or a theocratic country where religion will be the basis of our creation? Are we going to be a republic or are we going to be a monarchy? So what are the principles of a state? That's mentioned in the Constitution. What are the structures and processes of government? Will we have a parliamentary form of government or a presidential form of government? Will Prime Minister will have all the powers or President will have all the powers? What will be the fundamental rights of the citizens? Is right to privacy a fundamental right? Is right to marry a fundamental right? Is freedom of speech and expression a fundamental right? Is right to dignity a fundamental right? Those things should be mentioned in the Constitution, because these are the things that the state cannot change, that the government cannot violate. That means in Constitution, there are some restrictions mentioned. State, you cannot violate right to life of citizens. Governments, you cannot violate dignity of the citizens. You cannot discriminate against the citizens. You cannot deny them equality. So this Constitution is basically a limitation on the powers of the state. That means the government, that means the parliament, they are bound by this Constitution. They cannot go against this Constitution. So when a legislature is passing a law, it has to keep Constitution in mind. We cannot pass any law which will discriminate against the people. We cannot pass any law which will violate equality. We cannot pass any law which will deprive citizens of their dignity. So what is Constitution? Constitution is basically a rule book. Constitution is basically a sacred document. And this document basically tells us what are the basic principles of a state. State in the sense, the nation, the country as a whole. What are the basic principles on which the state is founded? Are we a secular or a theocratic country? Are we a republic or a monarchy? What are the fundamental rights given to the citizens? That cannot be unilaterally changed by an ordinary legislative act. What is an ordinary legislative act? For example, when Parliament passes a law, it requires simple majority. Simple majority in the sense we will discuss today. Basically, all the members who are present, if more than half of them agree, this law will be passed. Let's say this law talks about, can we launch a new scheme? For example, budget, some new scheme will be passed. This scheme will be passed by simple majority. More than half of the members agree, this scheme will be passed, this law will be passed. But can through this ordinary law, you change the Constitution? No. Why? Because I told you to change the Constitution, you require a tougher majority, which is 2/3 majority. So these principles on which our state is founded, these fundamental rights which have been given, cannot be unilaterally changed by an ordinary legislative act. You can change these provisions of the Constitution only by a special majority, only through a special law, not through an ordinary law. And this higher law is referred to as the Constitution. So what is this higher law? The supreme law of land, which enjoys special legal sanctity. Long story short, we have to study Indian polity for the civil services exam because it's relevant for prelims, mains, essay, personality test. Clear? It's relevant for the exam. What exactly do we have to study in Indian polity? Three things: constitution, laws passed by the parliament, judicial verdicts. Clear? But if we have to study the constitution, first we should know what is a constitution. So what is a constitution basically? Constitution is a document which tells us how India will be governed. In India, will we have all the powers with the center, or there are some powers which will be given to the state governments as well? That will be mentioned in the constitution. In constitution, what are those basic fundamental rights that are to be given to every citizen? That's mentioned. So constitution is basically a supreme law of land which enjoys special legal sanctity. That means no law passed by the parliament, no rule issued by the executive can violate the constitution. And constitution allocates roles and responsibilities to different organs of the state. What is the role of legislature? What is the role of executive? What is the role of judiciary? And this constitution cannot be changed through an ordinary law by simple majority. If it has to be changed, it requires a special majority. And this higher law is called the constitution. Now, any questions, please let me know, then we will discuss. Sir, in Shreya Singhal case, Supreme Court declared Section 66A as unconstitutional. But there is a report that police is still filing FIR in arresting people based on this provision. Why is it so? Is this not a sign of a police state, not justice and democratic state? You're right, but that only means there is a misuse. Misuse in the sense, and Supreme Court has come down heavily on this. Some policemen, they are not trained and made aware that such a section has been deleted by the Supreme Court or declared unconstitutional by the Supreme Court. So unaware police is arresting people under a section which has been declared unconstitutional by the judiciary. But even if you are arrested under Section 66A, all you have to do, approach the court will set you free because you are booked under an illegal law. If constitution is super, but how change Article 370 to J&K? We will discuss that in Jammu and Kashmir chapter. Executive, can you please explain in simple terms? Executive, for example, Prime Minister and his Council of Ministers. They implement the laws passed by the Parliament. They carry on the general administration of the country. These are part of the executive. Simple and special majority, key differences. Again, I'll explain all these majorities today. Shalu, what's your question? Sir, most of the Supreme Court judgment police will not up to date. Why recent case of pregnancy termination? Can you please elaborate your question? Was Section 66A added to Constitution? It was added to a law passed by the Parliament called Information Technology Act. Information Technology Act is not mentioned in the Constitution. What is Constituent Assembly? A group of people who were responsible for making the Constitution. For example, Dr. Rajendra Prasad, Dr. B.R. Ambedkar, Pandit Nehru, Sardar Patel, Maulana Azad, all these were part of the Constituent Assembly because they got together to draft the Constitution, to write the Constitution. So Constituent Assembly was a group of people who were responsible for making Indian Constitution. Okay. Now, when constitution is something that we know what is a constitution, then there is one category, or there are two different forms of a constitution which you must know. Two different types of the constitution. Constitution can be unitary, constitution can be federal. Who sits in Rajya Sabha, who sits in Lok Sabha? We will discuss everything one by one. But if we discuss everything today, which means today we have to complete the entire syllabus. For Rajya Sabha, we will have a separate lecture altogether. For Lok Sabha, we will have a separate lecture altogether. So take it easy. One by one, we will discuss everything. I will not leave anything. There are some students who are asking for break. If you're asking for break, today, since it's the first class, we'll give you a break as well. We'll give you break every class for 10-15 minutes. So it's 7:33. Let's meet 7:47 a.m. because once we start unitary versus federal debate, then I can't leave it midway. I cannot give you further break. So take a break for 10-15 minutes. We'll be back at 7:47 and then discuss the remaining provisions. See you on the other side of the break. Shall we start? Okay. Now we know what is a constitution. Constitution is the supreme law of land which enjoys special legal sanctity. Now there was a question, sir, why is it that all laws are not mentioned in the constitution? I'll give you a simple example for that. Constitution tells GST Council that you will decide what should be the GST rate. Clear? If GST rate itself is mentioned in the constitution, then it would make it very difficult to keep altering the GS rates, because then it would require 2/3 majority every time we have to change the GST rate. That is why Constitution has said, yes, GST can be imposed. What will be the rate of the GST? That GST Council will decide. And GST Council will meet and will decide what should be the GST on the restaurants, what should be the GST on insurance, what will be the GST on sindoor, what will be the GST on sanitary napkins. So it becomes easier for this GST Council to change the GST rates. If the GST rate itself was fixed in the constitution, then it would become difficult to change the rates every now and then, because every time we have to change, we have to seek 2/3 majority from the parliament. That's why constitution will give the broad framework, will give the broad rule book of how the country will govern, but how exactly it will be governed will be based on the laws which will be passed by the parliament, and these laws will have to be passed keeping in mind the constitutional provisions. Clear? Now the constitution can be either unitary or the constitution can be federal. What is a unitary constitution? For that, unitary constitution, something we see in United Kingdom or something that we see in South Africa. And to understand what is this unitary constitution, we need to understand the difference between delegation of power and distribution of power. What's the difference? For example, in India, we have 28 states, clear? And then we have a center. That means Parliament of India is making law for the entire country. On what areas? For example, foreign policy will be decided by the central government. For example, banking will be decided by the central government. Insurance will be decided by the central government. Citizenship matters will be decided by the central government. But what will then these states do, 28 states do? For example, Bihar, Uttar Pradesh, Karnataka, Kerala, Tamil Nadu. What will these states do? They will make laws in their own areas when it comes to land, when it comes to police, when it comes to law and order, when it comes to gambling, when it comes to agriculture. That means we have clear-cut distribution of powers. Some powers are given to the center. For example, banking, insurance, citizenship. Some powers are given to the states. For example, law and order, land, agriculture, gambling, police. If, for example, we do not have 28 states in India, we have one big entity known as India, and the Prime Minister and the Parliament of India will be the only two institutions in India. In a sense, Parliament of India will make a law on land as well, agriculture as well, gambling as well, police as well, citizenship as well, foreign policy as well, banking as well, insurance as well. That means that all the powers are concentrated with one body that is known as Parliament. That means then these state legislative assemblies will not exist because they will have no role. Their role is now given to the Parliament of India, central parliament, Lok Sabha and Rajya Sabha. Lok Sabha and Rajya Sabha will make laws for the entire country, including on land, law and order, agriculture, gambling, so on and so forth. That means in a unitary constitution, all powers are concentrated with the center. All powers are concentrated with the center. That means states do not exist. Or even if state exists, there is delegation of power. There is no distribution of power. What is the difference? For example, I run this class right now, but we have an individual who manages the studio. We have an individual who manages the audio, video equipments. We have an individual who manages the lights. We have an individual who manages the screen. We have an individual who takes care of the internet. Clear? So we have clear-cut distribution given. One individual will take care of the camera. The another individual will take care of this device. The another individual will take care of whether the AC will work or not, whether the internet will work or not. So clear-cut, the powers are being distributed. What if it is not distribution of power, it is delegation of power? In a sense, all this is my responsibility. To take care of this class, to ensure that the screen is working, to ensure that the camera is working, the audio equipment is working, the lights are working, the pen is working, the AC is working, the internet is working. Assume that all these are the powers with me and only with me. That means all the powers are concentrated with one individual. I get to decide everything. But it may not be administratively possible as well, because then I have to come very early to ensure the setup, to ensure that the screen is working, to ensure audio video is working, to ensure the lights are working, to ensure the AC is working, to ensure the pencil is working. So to make the class better, smooth and streamline this class, we have different people with different responsibilities. So to govern this class better, we have different areas of responsibility given to different sets of people. That's how we can make this class smooth. That means we have distributed the responsibility. What if it is not distribution, it is delegation? Delegation in the sense, I am the superior body. I get to decide which individual will take care of this pencil, which individual will take care of the camera, which individual will take care of the audio, which individual will take care of the AC and the internet. That means the ultimate power is with me. But I can snatch these powers at any point in time. I can say all these people are sacked. I will take over the responsibility. I will ensure everything works. And if today it is your responsibility to ensure that the screen is working, tomorrow I can give this responsibility to someone else. If today it's your responsibility to ensure AC and internet is working, tomorrow I can give this responsibility to someone else. That means in delegation of powers, power is concentrated with one superior body. And this power is with me. I can at any point in time share this responsibility with someone else. And at any point in time, I can snatch that responsibility as well. That's what happens in a unitary constitution. Unitary constitution, for example, South Africa. Unitary constitution, for example, United Kingdom. United Kingdom, for example, all the powers are concentrated in London. In the sense, we have the Parliament of United Kingdom in London. This parliament makes law for the entire country. We have the executive, which is the Prime Minister and his ministers. Mr. Rishi Sunak is the Prime Minister. He gets to implement the laws passed by the Parliament in the entire country. Does that mean that there are no local bodies? There can be local bodies. But powers to these local bodies are delegated for administrative convenience. Delegated in the sense, some of the powers are given to these local bodies that you take care of sanitation. You take care of law and order. you take care of police. But the real power is still with London. The real power is still with the center. In center, we have the parliament. In center, we have the prime minister and his council of ministers. The real power is with them. But since they cannot govern conveniently, administratively better, they delegate some powers to these local bodies. But at any point in time, they can dissolve these local bodies. At any point in time, they can snatch these powers from the local bodies and they can concentrate all these powers back. That is what we call a unitary constitution. Sir, what is a unitary constitution? First, we know what is a constitution. Yes, sir. Now, constitution can be either unitary or constitution can be federal. Sir, what is a unitary constitution? In unitary constitution, all powers are concentrated in the center. That means in United Kingdom, in center, which is London, where the parliament is situated, where the prime minister and his council of ministers are working, all powers are with them. All powers in the sense, power to make laws, power to implement laws, power to make rules for the entire country. Does that mean there are no local bodies? There can be local bodies as well. But these local bodies, there we have delegation of power. Delegation in the sense, power is still with the center, but center may say, sanitation you take care of, law and order you take care of, police you can take care of. But at any point in time, the center can say, no, enough is enough. Power, give us back. Sanitation, give us back. Law and order, give us back. Agriculture, give us back. That means center has the ultimate power. Center controls everything. All powers are concentrated with center. That is what we call a unitary constitution. But then what is a federal constitution? The problem is we don't know. Why? Because there is no definition. Sir, why? Because we don't know. Sir, what are you saying? I'm saying we have a definition for a unitary constitution. Sir, what is that definition? In a unitary constitution, all the powers are concentrated in one strong center. There may be local bodies created by the center. There may be local bodies abolished by the center. So these local bodies, they are at the mercy of the center. At any point in time, they can be created. At any point in time, they can be dissolved. What are the powers to be given to them? That center will decide. Center will today give them police power, tomorrow will snatch that power. Center can give them law and order solution, tomorrow law and order power can be snatched from them. That means all powers are with the center. But what is a federal constitution? We don't know because there is no definition. Then what do constitutional experts do? Constitutional experts, they take a look at what these constitutional experts do. They look at the US Constitution, which is considered to be the oldest federal constitution of the world. So here is a constitution of any country, A, B, C, X, Y, Z. Is this constitution unitary or federal? How do we decide? If all the powers are concentrated with the center, if there is delegation of power, we call this constitution a unitary constitution. But is this constitution federal? For that, we have to compare this constitution with the Constitution of United States of America. If this constitution matches the Constitution of US, we call it federal. But what are the characteristics of US Constitution which makes it a federal constitution? What are the characteristics on the basis of which we say that the US Constitution is federal? 5 characteristics. Which are these 5 characteristics? Number 1, dual government. What is dual government? One government at the center, government in every state as well. So we have United States of America, which has 50 states as well. There is government at the center headed by Joe Biden. There is government in all the 50 states as well, headed by their respective governors as well. So there is dual government. One government at the center, one government in the state as well. That is first criteria why US Constitution is called Federal Constitution. Because in a unitary constitution, we have only one strong government which is at the center. There are no governments at the states. Or even if there are governments at the states, powers are delegated. Powers are not distributed. So criteria number 2, why US Constitution is federal? There is a dual government, but at the same time, there is distribution of powers. Powers are distributed by the Constitution itself. Constitution says that these are the powers given to the states. States can pass their own criminal laws, states can pass their own civil laws, states can decide their own taxation, states can have their own constitution as well. So Constitution has given some powers to the states, some powers to the center. In a unitary constitution, it is the center which decides what powers to be allocated to the states, what powers to be delegated to the states. But at any point in time, these powers can be snatched as well. But that cannot happen in a federal constitution, in a federal polity. Because what are the 5 characteristics? Number 1, dual government. One government at the center, government in every state as well. Second, distribution of powers, not delegation. Because delegation is when a superior body gives responsibility to an inferior body. But at any point in time, this responsibility can be snatched. So delegation in a unitary constitution is done by a superior body which is at the center to an inferior body which may be there in the states. But at any point in time, these powers can be snatched. But in a federal constitution, there is distribution of powers, which means we have distributed. These are the powers with the states. These are the powers with the center. Center cannot encroach into this domain. States cannot encroach into the center's domain. Clear-cut distribution of powers. Third criteria, Constitution should be written. What is a written constitution? This is where we come across another classification. Constitution can be written, constitution can be unwritten. For example, Indian Constitution, US Constitution is a written constitution. Britain Constitution is unwritten. New Zealand Constitution is unwritten. What does that mean? A written constitution is one where laws are written and codified into one single document. What does that mean? If you ask me, show me the Constitution of United States, I will take out a pamphlet and tell you this is the Constitution of United States. Sir, show me the Constitution of India. I'll take out a bulky book with 12 schedules, with 25 parts, with more than 444 articles, and tell you this is the Constitution of India. That means laws are written and they are codified into parts. Parts in the sense, we start with preamble, then part 1 is union and its territory. Part 2 is citizenship. Part 3 is fundamental rights. Part 4 is directive principles of state policy. Part 4, capital A, is fundamental duties. Part 5, Part 6, till Part 25. Similarly, what about Constitution of United States? All the legislative powers are with the Congress. It's not Rahul Gandhi's Congress, it is US Congress. US Parliament is known as US Congress. So all the legislative powers are with the Congress. All the executive powers are with the President of India, President of United States. All the judicial powers are with the Supreme Court. That means in United States, in India, laws are written and codified into one single document. This document is the Constitution. That means the Constitution is written. But in United Kingdom or in New Zealand, they have unwritten constitution. unwritten constitution in the sense laws are written but not codified into a single document. If you ask me, sir, show me the Constitution of United Kingdom, I will probably take you to a library and tell you this is the UK Constitution. Laws related to human rights are mentioned there. Laws related to the role of the Queen is mentioned here. Laws related to the office of the Prime Minister is mentioned here. That means laws are written, but they are not written into one single document. Sir, why? Are they lazy? Perhaps. We also have to understand where a country is coming from. What is the history of a particular country? Britain has never felt a need to codify all these laws into one single document because they have functioned like this forever. They never felt the need that all these laws that we have, they should be codified together and mentioned into a single document. That is why we say UK Constitution is unwritten. That means laws are written, but they are not written into a single document. Why? Because they never felt the need. If tomorrow they feel the need that all these laws should be written into one single document, maybe they will make a written constitution. But as of now, they never felt the need. That's why we say their constitution is unwritten. But in an unwritten constitution, conventions play a role. What is a convention? Unwritten rule. What does that mean? Listen to me carefully. For example, when a bill, what is a bill? Bill is a proposal. What is a proposal? For example, the proposal is to add a fundamental right to the Constitution. Let's say a right to safe drinking water and sanitation should be a fundamental right mentioned in the Constitution. This is a proposal. That means this is a bill. Bill to add right to safe drinking water and sanitation, a fundamental right to the Constitution. This bill, this proposal is to be given to the Parliament. When Parliament will approve this bill by 2/3 majority, it will be added to the Constitution. But this bill, once it is passed by both houses of the Indian Parliament, Lok Sabha as well as Rajya Sabha, it is sent to the President for signature. Once President signs this bill, then this bill becomes an act, it becomes law of the land. Similarly, when a bill is passed by the US Congress, by the US Parliament, it is sent to the President of the United States for signature. Once the United States President signs this bill becomes an act, it is to be implemented. But can President of United States not sign this bill or sign this bill or send this bill back? This is mentioned in the Constitution. This is mentioned in the Constitution that US President may sign this, may not sign this, may return this bill to Parliament for reconsideration. This is mentioned. But in UK, Constitution does not mention this. But they have a convention. What is the convention? Unwritten rule. What is the unwritten rule? That means a rule which is not mentioned anywhere, which is not written anywhere, but they follow this. What is that convention? Whenever UK Parliament passes a bill, sends it to the Queen, Queen has to sign it. This is not mentioned anywhere. This is not mentioned in any law. This is not mentioned in any book. This is not mentioned in any document, on any paper. But this is an unwritten rule. This is a convention that they have been following. Whenever a bill is passed by the UK Parliament, sent to the Queen, whenever the bill is passed by the UK Parliament, sent to the Queen will sign it. It's not mentioned anywhere, but it's a convention. So in an unwritten constitution, apart from those things which are mentioned in the laws, although they are mentioned separately, but apart from the things that are mentioned in the laws, there are conventions, unwritten rules which play an important role. But what is Indian Constitution? Only that much which is mentioned in the document. What is US Constitution? Only that which is mentioned in the document. Only that which is mentioned in the law. But in UK Constitution, which is an unwritten constitution. Not all laws are written, because there are some unwritten rules which they follow. And because of these unwritten rules, we call UK constitution as an unwritten constitution. But there is a big fundamental difference. In a written constitution, constitution is supreme. In an unwritten constitution, Parliament is supreme. Sir, what does that mean? Constitution is the supreme law of land which enjoys special legal sanctity. Which means any law passed by the Parliament cannot violate the Constitution. Any rule issued by the executive cannot violate the Constitution. Which means in written constitutions, it is the Constitution which is powerful. It's the Constitution which is supreme. Parliament in these countries cannot violate the Constitution. Parliament in these countries cannot go against the spirit of the Constitution. But in an unwritten constitution, it is the Parliament which is supreme. Parliament can do anything. That's what D. Lolme, a constitutional expert in Britain, he said British Parliament can do anything except convert a man into a woman and a woman into a man. British Parliament, according to D. Lolme, can do anything, even except convert a man into a woman and a woman into a man. It can do anything. That means it can make any changes. It can pass any kind of law. There is no restriction on the Parliament. There is no limitation on the Parliament. Parliament can do anything, because in Britain, they have an unwritten constitution. And in an unwritten constitution, where the laws are written, but not codified into a single document, where not all laws are written, because there are some conventions to follow as well. And in such a system, Parliament can do anything, pass any kind of law. There is no restriction, no limitation on the Parliament. But in a written constitution, there is a limitation. Parliament, executive, cannot violate the Constitution. It is the Constitution which is supreme. So why US Constitution is known as a federal constitution? Because of its 5 characteristics. Characteristic number 1, dual government. One government at the center, one government in the states. Characteristic number 2, distribution of powers. Some powers given to the center, some powers given to the states. States cannot encroach into the powers of the center. Center cannot encroach into the powers of the states. Third, written constitution. Because we need a dual government, it should be mentioned somewhere. And it is mentioned in a written constitution. That we have distribution of powers. These powers are given to the center, these powers are given to the states. It should be mentioned somewhere. That is a written constitution. Characteristic number 4, which makes US Constitution a federal, is that this constitution should be rigid as well. Rigid constitution means rigidity does not mean that you can't change the constitution. Rigidity does not mean that it becomes very difficult to change the constitution. Rigidity means if at all this constitution has to change, has to be altered, has to be amended, it must be a joint act. Joint act of both center as well as states. In US, if the constitution has to be changed, only the central parliament, US Congress, cannot change the constitution. US Congress and the state legislatures together, they have to come and change the constitution, alter the constitution, modify the constitution, amend the constitution. That is why we say rigid constitution. So rigidity does not mean that you can't change the constitution, or it becomes very difficult to change the constitution. Rigidity means if at all there is a need to change, modify, alter, amend the constitution, it must be a joint act. Both center as well as states should come together to change the constitution. Only states cannot change the constitution. Only center cannot change the constitution. And fifth important criteria, characteristic that makes US Constitution a federal constitution is independent judiciary. What is independent judiciary? Judges who have the responsibility of upholding this constitution. What if Joe Biden is violating the constitution, snatching the powers of the state? Independent judiciary, which is not biased in favor of the center, which is not biased against the states. Independent judiciary, whose only job is to check the constitution, uphold the constitution, strengthen the constitution. These judges will stop the US president from violating the powers of the states. If the states are encroaching into the domain of the center, the judiciary, independent judiciary, which is not biased, independent judiciary will restore this constitution, will not allow the states to snatch the powers of the center. So what is a constitution? It's a supreme law of land which enjoys special legal sanctity. It's this document which reflects people's faith and aspirations. It is this document which allocates roles and responsibilities to different organs of the state. It is this document which tells us what should be the nature of the Indian state, what should be the principles on which our state is founded, on which our country is founded. But the constitution can be unitary, can be federal. What is a unitary constitution? All powers are concentrated with center. There may be states created, but states are created only for administrative convenience. In a sense, at any point in time, states can be created, states can be dissolved. At any point in time, powers can be given to the states. At any point in time, powers can be snatched from the states. That means if India was a unitary constitution, we have the parliament in New Delhi, and we have the Prime Minister and his Council of Ministers in New Delhi. Prime Minister and the Parliament will decide what will be the role of Bihar Legislative Assembly, what will be the role of the Tamil Nadu Legislative Assembly, what will be the role of the Chief Minister of Karnataka, what will be the role of the Chief Minister of Rajasthan. And at any point in time, the center can dissolve a state. We don't need a state government in Rajasthan. We don't need a state government in Karnataka. All the powers will be given back to the Prime Minister. We don't need a legislative assembly in Chhattisgarh. We don't need a legislative assembly in Telangana. All the powers will be given to the parliament. Parliament will make law for the entire country. If such a situation was there in India, we would have called India a unitary constitution. But if this is the feature of a unitary constitution, what about a federal constitution? Which constitution can be called federal? We don't know. Why? Because there is no definition. Then what do these constitutional experts do? Constitutional experts, they compare a constitution with the Constitution of United States of America. If it matches US Constitution, it is federal. If it doesn't, then it is something else. But what are the features of US Constitution which makes it a federal constitution? 5 features. Feature number 1, dual government. One government at the center, one government in the states. Second, distribution of powers, not delegation, because delegation can be temporary. Delegation of power today, tomorrow the power can be snatched. But in a federal constitution, there is distribution of powers. Some powers given to the center, some powers given to the states, and they cannot interfere with each other. But for that, constitution should be written. Because written constitution should clearly demarcate areas and responsibilities of center and the states. This constitution, which should be supreme, and at the same time, this constitution should be rigid. Rigidity does not mean that you can't change the constitution. Rigidity means if a constitution has to change, it must be a joint act of both center as well as states. And then independent judiciary. Judiciary should be independent, without any bias, without any favor. It should uphold the constitution. In any constitution, if these 5 features are present, then that constitution is a federal constitution. Let me ask you now, what do you think about Indian constitution? Are we unitary or federal? Prima facie, on the face of it, when we look at these 5 criteria, we say that Indian constitution is also federal. Why federal? Because criteria number 1, dual government. Do we have dual government in India? Yes, we have. There is a government headed by Mr. Modi at the center, or there is an executive headed by the president at the center. But in every state, we have the chief ministers. In every state, we have the governors. So we have dual government. Clear? Yes. Do we have distribution of powers? Yes, we have. How do we know that? There is something called Schedule 7 of the Constitution, which we will discuss in great detail later in subsequent lectures. In the Schedule 7 of the Constitution, there is clear-cut distribution of powers. How? In the form of union list, state list, concurrent list. Union list in the sense, Constitution under Schedule 7 of the Constitution has divided the powers between center and the states. Some powers are given to the center, and all these powers are mentioned in the union list. For example, on citizenship, for example, on foreign policy, for example, on banking, for example, on insurance. Who has the power to make laws? Only the Parliament of India, center. Then some powers are given to the states. For example, police, law and order, land, agriculture, gambling. I'm just giving examples. These are the powers which are given to the states. And then there are some powers which are mentioned under the concurrent list. Some subjects are mentioned under the concurrent list. For example, marriage. For example, divorce. For example, education. On all these subjects, both Parliament as well as the state legislatures have the power to make laws. That means our constitution specifically talks about the distribution of powers, not delegation, distribution of powers. Because delegation is by a superior authority to an inferior authority. Here, constitution has created center, created states, but center is not superior to state. States are not inferior to center. They have their own areas of influence. They have their own areas of responsibility. There is clear-cut distribution of powers. Do we have a written constitution? Yes. In fact, one of the lengthiest constitutions of the world is Indian Constitution. We have the written constitution. Is our constitution rigid? Yes. How? You would recall, if at all you can, if at all you know, that in 2017, a constitutional amendment was passed. This constitutional amendment led to the introduction of GST, Good and Simple Tax, or Goods and Services Tax, which Prime Minister Modi calls Good and Simple Tax. It's Goods and Services Tax. This GST was a constitutional amendment. That means GST was introduced into the Constitution. Constitution was amended when GST was introduced. But this GST bill proposal was first passed by both houses of the Indian Parliament, Lok Sabha and Rajya Sabha. then sent to all the states. When more than half of the states accepted GST, then this bill was sent to the president for signature. Only then GST could be introduced in this country. So there are provisions of the Indian Constitution which can be changed because of the joint act of both center as well as states. Both center as well as states, they come together to alter the constitution, change the constitution, modify the constitution, amend the constitution. So do we follow the fourth criteria of the US Constitution? Rigidity? Yes. Fifth, do we have an independent judiciary? Yes, we have a judiciary which is not biased in favor of the center, biased against the states. Judiciary is independent in discharging its constitutional obligation. So all these 5 criteria or 5 conditions or 5 characteristics are met by the Indian Constitution, which means Indian Constitution also is federal. But this is only on the surface. As we dig deeper, we see something else. What is that something else? If we have a dual government, but at any point in time, center can dismiss a state government by imposing something called as the president's rule. Under Article 356 of the Constitution. So if we have dual government, but dual government may also change. Change in the sense, center, the President of India, can dismiss a state government. Mamta Didi, you are dismissed. We are imposing President's rule in your state. And when West Bengal is under President's rule, who will govern West Bengal? Center. Maharashtra, the government is dismissed. President's rule imposed. Maharashtra will come under the central rule. Rajasthan, the government is dismissed. You will come under center rule. This doesn't happen in United States. So although on paper we are a dual government, where there is a government at the center, there is government in all the 28 states, but at any point in time, the center can dismiss a state government by invoking Article 356 of the Constitution, dismiss the elected state government, and this state will come under the central rule, will come under the control of the center. So dual government? No, we don't follow it in toto. But at least we follow distribution of powers. Distribution of powers in the sense, some powers given to the center, some powers given to the states. But Constitution says, on all the items mentioned in the state list, listen to me carefully. Constitution says, on all the items mentioned in the state list, the state legislature can, but only in normal circumstances, make a law. So on all the items mentioned in the state list, be it law and order, land, agriculture, gambling, on all these items, the state legislature can make a law, but only during normal circumstances. And which are these abnormal circumstances? That center will decide. And when there are abnormal circumstances, it is the parliament which can make a law even on state list. So there are some abnormal circumstances which we will discuss, where parliament makes a law even on a state list, where a central parliament makes a law on a state list. So how are we a federal polity? So we have dual government, but it looks slightly confusing because at some time, center can dismiss a state government, dual government is violated. Dual government clause is violated. Second, distribution of powers. Some powers given to the center, some powers given to the states. but only during normal circumstances. And which are these abnormal circumstances? That center decides. And when there are abnormal circumstances, then central parliament which make a law on state list as well. Okay. But at least ours is a written constitution, isn't it? Ours is a written constitution. But were states consulted in writing this constitution? No. Do states have a role in amending the constitution when we say we are a rigid constitution? Only in few matters states are involved in constitutional amendments. Only in few matters. For example, if there are some federal provisions of the constitution, such as Schedule 7 of the constitution, if you want to lift one item from the state list and you bring it to the union list, or you are taking one item from the state list and you are bringing it to the concurrent list, which means you are amending the constitution. In this case, state's permission is required. If you are changing something related to the manner and method of president's election, state's consent is required. If you are changing something regarding the Supreme Court and High Courts, the state's consent is required, but only on few matters. The majority of the constitution, the vast majority of the constitution, whether schedules, parts, fundamental rights, directive principles, fundamental duties, whether all things, if they are to be changed, states are not consulted at all, states are not involved at all. In fact, states cannot even propose a constitutional amendment. So how can we say we are a rigid constitution? But at least judiciary is independent. Judiciary is independent. Who appoints the Chief Justice of India? President. Center. Who appoints the judges of the Supreme Court? President. Center. Who appoints the Chief Justice of a High Court? President. Center. Who appoints the judge of a High Court? President. Center. So in appointment, states have no role. In removal, who can remove the Chief Justice of India? President. Who can remove the judge of a Supreme Court or High Court? President. But based on the resolution passed by the Parliament. If both houses of Indian Parliament, Central Parliament, pass a resolution saying, President, please remove the Chief Justice of a Supreme Court or High Court. Please remove a judge of a Supreme Court or High Court. Based on the resolution by the Central Parliament, the Central President can remove these judges. Where are the states involved? So now it looks confusing. We know what is a constitution. We know what is a unitary constitution. We know what is a written and unwritten constitution. We know what's a federal constitution as well. And we thought Indian constitution is federal. Because do we have dual government? Yes. Do we have distribution of powers? Yes. Do we have a written constitution? Yes. Do we have a rigid constitution? Yes. Do we have an independent judiciary? Yes. But as we dig deeper, we see something else. If we have dual government, then what is the role of president in dismissing a state government? If we have distribution of powers, then what are these abnormal circumstances when parliament can make a law on state list? If we have a written constitution, why weren't the states consulted in writing this constitution? If ours is a rigid constitution, why only on few matters states are consulted? More than 90% of the constitution can be changed without consultation with the states, without permission from the states. And if we have an independent judiciary, then why appointment is done by the center? Why removal is done by the center? States are not consulted at all. But then we have to realize that Indian constitution is unique. Just like India. Unique. Different. And that is why the term used for Indian constitution is quasi-federal. neither completely unitary nor completely federal. Or should we say that Indian Constitution has an amphibian character? Amphibian character in the sense, amphibians who can live both underwater as well as on land. Similarly, Indian Constitution is like an amphibian. It's both unitary as well as federal. We say Indian Constitution is federal in normal circumstances. Normal circumstances, it's completely federal. In abnormal circumstances, it changes its form and becomes unitary. What are these abnormal circumstances? Now, let me ask you a few questions and you tell me whether it is right or wrong. Suppose tomorrow there is a war. God forbid, if you believe in God, there is a war between India and China. Who is best equipped with dealing with the situation? Center or states? Center. Why? Because center has the army, center has the air force, center has the navy as well, center has the missiles as well, center has the nuclear weapons as well. So when it comes to a matter related to war, shouldn't during war we give all powers to the center so that center can deal with this emergency situation which has arisen out because of the war? Yes. So our constitution is federal during normal circumstances when there is no war. But when there is war, center becomes more powerful. Because center can then make a law on law and order, police, which is a state list. What's wrong with that? There is no harm. Because despite federalism, national interest is paramount. National interest is supreme. We can tomorrow have a fight between center and the state, but for that, the sovereignty of country has to remain intact. We have to first remain united as a country. There is a threat to the unity of this country because of China. And to deal with that emergency, to deal with that threat, center should be given more powerful. Center should be made powerful. Center should be given more power because it is more effective in dealing with the situation. Similarly, when we say dual government is violated, if it could have been violated at any point in time, then we would not have seen Ashok Gehlot as the chief minister for 5 years in Rajasthan. Modi ji would have dismissed him. President would have dismissed him. Mamta Didi would not have remained chief minister. So it's not like at any point in time the center can dismiss a state government. But if a state government is violating the constitution, shouldn't there be a mechanism where we can dismiss that state government and keep that government under the control of the center till the time fresh elections are conducted? So we violate dual government, but it is only for temporary period. Once the situation becomes normal in that state, elections are held again. And then elections are held again, they have their own government again. That happened in Punjab. When there was militancy in Punjab, where there was a rise of Khalistani movement in Punjab, where some sections of the society wanted a separate country known as Khalistan for the Sikhs.
Could you try again?
And then there was series of militant attacks and there was uprising in Punjab. Punjab was placed under president's rule. But once the situation became normal, elections were held and Punjab had its own government. So dual government is always there in normal circumstances. But whenever there is something abnormal, the center can dismiss that state government and control that state. But once the situation normalizes, it becomes a government again. They have their own government again, so dual government again. Distribution of powers. Right now, is Parliament making a law for the state of Bihar, for the state of Karnataka, for the state of Tamil Nadu? No. But tomorrow, if there is war, we need to deal with the situation. Parliament will make a law on state list. But once the war is over, then the state legislature can make its own law on law and order, own law on police, own law on agriculture. So we are in normal circumstances of federal polity. But whenever there is an abnormal situation, which may be war, which may be external aggression, which may be armed rebellion, which we will discuss later. And whenever there is a threat to the constitution in a particular state, that's where our constitution changes its form, changes its character, and becomes a unitary constitution. But that is only for a temporary period. Once the situation normalizes, stabilizes, comes back, then our constitution behaves as if it's a purely federal constitution. And that is why constitutional experts, they say Indian constitution is unique, just like India. And they have given a term to Indian constitution known as quasi-federal, where we say India is neither completely unitary nor completely federal. But we will keep this topic, we will keep this debate open. Whether India is a unitary polity or a federal polity, we will keep this open. And throughout our discussions on Indian polity, we will revisit this question, unitary versus federal. Why? Because there are some things known as centralizing tendency of Indian federalism. Despite the fact that we are a federal polity, we are a federal constitution, there are some provisions in the constitution which are biased in favor of a strong center, which gives more power to the center as against the states. Those provisions of the Indian constitution which are biased in favor of a strong center, which give more powers to the center, which makes center more powerful as against the states, those provisions are what we call centralizing features of Indian federalism. And we will discuss all these features one by one. In citizenship, in union and its territory, in taxation matters, in all these matters, we will discuss these provisions one by one. That is why I tell you, we will keep this topic open. We will keep this debate open, federal versus unitary debate. We'll keep this debate open so that whenever we discuss parts, articles of the Constitution one by one, I'm going to tell you, this feature is what makes Indian Constitution biased in favor of a center. This is the feature which makes Indian Constitution truly federal. This is the feature of the Constitution which makes it a purely unitary constitution. But if there is a name for Indian Constitution, we can call it Indian Constitution is quasi-federal, neither completely unitary nor completely federal. If you have any questions, please let me know, then we will jump to another part. Sir, how can we say that Indian Constitution is unitary because at 4 years was gone and no election are held in J&K? J&K is a different case. We will discuss that separately. That raises some issues. We'll discuss that separately. But look at the other parts of the country. There is no delay in the conduct of elections. Elections were conducted recently. Elections will be conducted now again. Elections are held on time in every other state. There is some peculiar problem with Jammu and Kashmir, which we will discuss separately. Judiciary appointed by judiciary, yes, but final order is issued by the executive, the President of India. So on the recommendations of the Supreme Court Collegium, judges are recommended to the President, but final order is issued by the President. That is why the question comes in the examination, who appoints the judge of the Supreme Court and High Court? Option A, President of India. Option B, Governor of a state. Option C, Supreme Court Collegium. Option D, Parliament. What is the answer? Answer is, my dear, the President. Clear? I did not say collegium system because it would be difficult for you to understand collegium in the first class. Once we will read judiciary, there we will discuss the collegium system. Mr. Gumnam, we'll discuss all these issues. Trust me, we'll discuss all these issues one by one, but we cannot cover everything in the first class. We'll have to take our own time one by one. That is why 24 classes are there where we have to complete the syllabus. Okay. This topic, federalism, we will cover towards the end as well in a completely different fashion. Completely different fashion in the sense, Constitution never mentions the term federal. So there is no mention of this word federal in Indian Constitution. That is why some constitutional experts say that federalism has emerged in India through various accidents. And that is why they say Indian Constitution is an example of accidental federalism. Accidents such as Panchayati Raj institutions, role of the judiciary, role and the rise of the regional political parties. But you will not understand it today. For that, we have to first complete the entire polity. Then towards the end, we will revisit the entire polity and look at the emergence of federalism. Clear? Have patience. I'm not running away. You just stay at your place. We'll cover everything. Sir, please tell me question, why Indian Constitution is not written? My dear, Indian Constitution is written. I am only responsible for what I say, not what you understand by that. I never said Indian Constitution is not written. Indian Constitution, like the US Constitution, is written, my dear. Okay, now let's look at another important concept, theory of separation of powers. And this theory has been attributed to French philosopher Montesquieu. Now, what is this concept all about? Let's say here is a king or a dictator. He makes his own law. He implements his own law as well. And then he sits on the judgment whether people have committed crimes or not, whether people have violated these laws or not, and I will punish those people who have violated these laws. Is this democracy or is this dictatorship, monarchy, a despotic regime, highly reprehensible regime? It's not democracy, because we are giving all the powers to one individual, or all the powers to one institution, or all the powers to one body. Accumulating all powers to one body or one individual may be pronounced as the worst example of tyranny. It's a despotic rule. That's why Montesquieu said, powers that are there should be separated in a watertight arrangement, and different organs should be given different powers. What are these different organs? For example, this is the Parliament of India. The job of the Parliament is to make laws. That means Parliament is the legislature. No other entity can be empowered to make a law. Only the Parliament should have the power to make laws. Then we have executive. It should be the job of the executive to carry on day-to-day administration of the country, to take care of law and order, to take care of police, to take care of taxation. It should be the job of the executive to deal with the working of the country, daily administration of the country. And this is our judiciary. What is the job of the judiciary? One, the job of the judiciary is to punish those who violate laws. You have committed murder, you have committed rape, you have committed dacoity, you have committed an act of terror. There should be a separate body which should decide whether you have committed crime or not. Why separate body? Listen to me carefully. If all these powers are with me, I am the judge, jury, and the executioner. I am making laws. I am implementing laws. I am also deciding whether you have violated these laws or not. Which would basically mean if I have made a law, I am implementing a law, I can tell anybody you have not followed this law, you are guilty of committing this crime, you are guilty, you are hanged by your neck till death. This will be a tyrannical rule. This is just like monarchy. This is just like dictatorship. Montesquieu said, powers that are there in a state, whether there are legislative powers, executive powers, judicial powers, they should be separated. Separated by creating three organs: legislature, executive, judiciary. And they should be completely separated from each other. Separated in a watertight arrangement. Watertight arrangement in the sense, if you are a member of legislature, you cannot be part of the executive. If you are part of the executive, you cannot be part of judiciary. If you are part of judiciary, you cannot be part of legislature. That means different set of people should be responsible for making laws. Different set of people should be responsible for implementing the laws. Different set of people should be responsible to provide justice to the people. Separate all the three. That is what Montesquieu said is theory of separation of powers. And United States of America was the first constitution, was the first country to implement this theory of separation of powers in their constitution. How? Article 1, 2, and 3 of US Constitution clearly implements separation of powers. Article 1 says all the legislative powers are with the US Congress, which means who will make laws for the entire country in United States? For that we will have a parliament known as US Congress. And US Congress will have two houses, two branches. One will be the House of Representatives, the other will be Senate. Just like India, we have the parliament at the center, but it has two houses. Lower house is known as Lok Sabha, upper house is known as Rajya Sabha. What is the role of both these houses? We will discuss later. But here, just like India, United States also has a bicameral legislature. What is bicameral legislature? That means a legislature which has two chambers, two houses, House of Representatives, Senate. All the legislative powers are with the US Congress. That means who alone can make a law? Parliament. All the executive powers are with the President of the United States of America. All executive powers will be with the President of the United States of America. Third, all the judicial powers shall be with the Federal Supreme Court. And United States Constitution ensured that there is a watertight arrangement. Watertight arrangement in the sense, US Congress, is the US President part of the US Congress? No. Is the President of United States of America part of the US Parliament? No. Because executive is separate, legislature is separate. No member of legislature is part of the executive. All the ministers, Anthony Blinken, the foreign minister of United States, the foreign secretary of the United States, he is not part of the Congress. He is not part of the Parliament of United States. Separation of powers, clear-cut separation of powers. and the judiciary of United States separate. That means the president is not part of the judiciary. Congress members are not part of the judiciary. Judiciary will have its own members, executive will have its own members, legislature will have its own members. So the United States implemented what is known as separation of powers. But United States constitution makers also realized a danger in the separation of powers. They said if we implement this theory of separation of powers completely, then we run a danger. What is the danger? Montesquieu had basically said that all the three organs should be separate from each other, separate in two senses. Sense number one, members of legislature cannot be part of executive and judiciary. Members of executive cannot be part of judiciary and legislature. Members of judiciary cannot be part of legislature and executive. Clear-cut separation. That's separation number one. Separation number two, they should not be able to influence each other. So legislature should not influence the judiciary. Judiciary should not influence the executive. Executive should not influence the legislature. That means they should have no scope to influence each other. They should be separate. United States constitution makers realize that there is a danger. Danger in the sense, if legislature has all the powers to make laws, if legislature has all the powers to make laws, and judiciary and executive cannot interfere, what is the danger? The danger is legislature of United States can pass a law which can violate constitution as well. If there can be no check on executive, executive may say, I will not implement your laws. I will make my own rules. Judiciary will say, only the blacks will be prosecuted. Person of fair color, we will not prosecute them. That means judiciary will run its own thing. Legislature will do its own thing. Executive will do their own thing. If we implement separation of powers as depicted by Montesquieu. Sir, we are not able to understand. Okay. What is separation of powers? A theory which is attributed to French philosopher Montesquieu. What does he say? He said that there should be a tripartite system. Tri-system. All powers that are available with the state, that are available with the country, all these powers should not be given to one body or one institution or one individual. These powers should be separated. Give legislative powers to legislature. Give executive powers to executive. Give judicial powers to judiciary. No member who is part of judiciary can be part of legislature, and vice versa. No member of executive should be part of legislature, because legislature should have its own role, executive its own role, judiciary its own role. United States Constitution said we will implement this. Article 1, Article 2, Article 3 implements separation of powers. Article 1 says all legislative powers with the Congress. Article 2 says all the executive powers with the President of the United States of America. Article 3 says all the judicial powers vested with the Federal Supreme Court. But they also realized a danger. If there is separation of powers, but at the same time, there is no check on an organ, which means legislature, if it has the job of making a law and no other organ can keep a check on legislature, legislature can pass any law. Legislature can violate constitution as well. Executive can have its own rules. Judiciary can have its own rules. We will give justice to some, we will not give justice to others. This will lead to a scary situation. And that is why United States Constitution, apart from implementing theory of separation of powers, implemented a doctrine known as checks and balances. What is checks and balances? Yes, legislature alone will make a law. No other entity is having the responsibility of making a law. But if this law violates the Constitution, if this law is unfair, if this law is unjust, if this law is unreasonable, Supreme Court will declare this law as unconstitutional. So what will judiciary do? Keep a check on legislature. Legislature, if you are abiding by the Constitution, passing a laws in agreement with the Constitution, we have no problem. But the moment you violate the Constitution, we will stop you, we will keep a check on you. Because although judiciary will not make a law, but judiciary will keep a check on the legislature if the legislature is violating the Constitution. Same goes with executive. Mr. Joe Biden, you are head of the executive. Yes. You are the president of the United States of America. Yes. What if you commit treason? What if you commit highest offenses against the state? We will remove you from your office. Who will remove you from the office? Legislature. Judiciary. If you violate something, we will keep a check on you as well. And if there is a judge who is doing this, we will have the power to remove that judge as well. And who will remove that judge? Jointly by the executive and the legislature. That means apart from implementing the doctrine of or the theory of separation of powers, the US Constitution to keep a check on every organ. Because unless and until there is check, there can be disastrous consequences for the nation as well. There has to be somebody to keep a check on each organ. So all these three organs keep a check on each other. Executive is kept under check by the legislature. Legislature is kept under check by the judiciary. And these two organs keep a check on the judiciary as well. And this is how doctrine of checks and balances was implemented in the United States of America. So what is this separation of powers? Tripartite system, as I told you, which is commonly attributed to French philosopher Montesquieu. Although Montesquieu did not use this term, separation of powers, Montesquieu basically used the term distribution of powers. Power should be distributed between legislature, executive, and judiciary, but we call it separation of powers. And in his book, In the Spirit of Laws, Montesquieu described various forms of distribution of political power among legislature, executive, and judiciary. In this tripartite system, the approach of Montesquieu was to present an alternative where excessive powers are not given to one individual or one institution or one body. Powers are distributed. And when powers are distributed, it leads to a smooth functioning of the government as well. It leads to quick decisions as well. Because if I have to take legislative, executive, and judicial decisions together, I will prioritize one set of decisions and will deprioritize other set of decisions. But if these powers are distributed, now one organ deals with legislative powers, other organ deals with executive powers, other organ deals with judicial powers, there can be quick delivery of justice as well. Quick decisions can be taken by the state. James Madison, he was the president of the United States of America. He wrote a beautiful line. He said, concentration of all powers, be it legislative, executive, judiciary, concentration of all these powers in one hand or in one individual may be justly pronounced as the very definition of tyranny, a despotic rule, which goes against the spirit of democracy. What about India? What sort of structure do we follow in India? Listen to me carefully. India and United Kingdom. We have got a lot of inspiration from United Kingdom. If you look at provisions of Indian Constitution or the kind of system of government that we have, the parliamentary form of government that we have, where Prime Minister has the real power, although we have the President as well, but the Prime Minister has the real power. All these have been borrowed from the traditions of United Kingdom. Why? For two reasons. One, because the country is diverse. Number one. Number two, because we were under colonial rule for a large number of time, and we were exposed to this British system for a number of years. That is why when the constitution was to be framed by India, we borrowed major provisions in Indian constitution from United Kingdom, because we were exposed to their policies. We were exposed to their systems of government. And in India, we follow parliamentary democracy. What is this parliamentary democracy? Listen to me carefully. Nidhi Manju is asking, what is POTUS? POTUS, my dear, is the full form of President of the United States of America. Clear? We follow parliamentary democracy. And what is this parliamentary democracy? Council of Ministers are accountable to Lok Sabha. Or lower house of Indian Parliament. What does that mean? There can be either a presidential form of democracy or a parliamentary form of democracy. Presidential form of democracy, for example, in United States, where president is the executive head, where real power to run the country is with the President of India, President of the United States. But there is a parliamentary form of democracy where the real power is with the Council of Ministers headed by the Prime Minister. For example, in Britain, for example, in India, the real power is with the Prime Minister and his Council of Ministers. Although we have a president, just like they have a queen in England, but the real power is with the Prime Minister and his Council of Ministers. Real power is not with the president or the queen. Same parliamentary democracy we followed in India as well. We follow in India as well. But in a parliamentary democracy, there can be no separation of powers between executive and legislature. What does that mean? Mr. Modi is the Prime Minister. That means he is part of the executive, but he is also part of the legislature. He represents Varanasi in Lok Sabha. Mr. Amit Shah is a member of the Executive Council of Ministers. He is also the member of the Parliament. Mr. S. J. Shankar is the minister, but he is also the member of the Rajya Sabha, which means the member of the legislature. Similarly, in United Kingdom, all the ministers and the Prime Minister, they are necessarily part of the Parliament as well. That means in a parliamentary form of democracy, executive and legislature cannot be separated from each other in a watertight arrangement. Because in a presidential form of democracy, members of executive are not part of the legislature. They are not part of the judiciary. Clear-cut separation of powers. Which means the President of the United States is not part of the US Parliament. Ministers of United States, they are not part of the US Parliament because they follow a presidential form of democracy, where the presidential form of democracy means that the members of the executive, they are not part of the legislature. But the presidential form of democracy may not represent the entire country. In a parliamentary form of democracy, since we have chosen parliamentary form of democracy, I told you we have chosen this because of our diversity. What is the diversity? President of US can choose any person as the minister. Any person. You don't have to be necessary. You don't have to be a member of parliament. Then the choices are restricted. I have to choose only that minister who is also a member of the parliament. But President of US has no such restriction. He can choose any person as the minister. That means he doesn't have to take into account the various caste factors, religious factors, regional factors, linguistic factors in deciding his ministry. But in a parliamentary form of democracy, where we have the Prime Minister and we have the Council of Ministers, Prime Minister chooses these Council of Ministers who are part of the Parliament, representing various states in India, representing various caste groups in India, from different religious groups in India, from different regions of India, from different linguistic groups in India. That means parliamentary democracy is best suited for countries which are culturally very diverse, such as India. And in a parliamentary form of democracy, there can be no strict separation of powers between executive and the legislature. Because we draw executive from the legislature. In a sense, if you are not a member of the legislature, you cannot be made a minister. There is an exception. Exception for some time. What is that exception? Can Mr. Modi ask me today that you become Minister of External Affairs? Yes. But I'm not a member of parliament. I'm neither a member of Lok Sabha nor a member of Rajya Sabha. But I can be appointed as a minister today, but within 6 months, I have to get myself elected to either Lok Sabha or Rajya Sabha. If I cannot get myself elected to either Lok Sabha or Rajya Sabha, I cannot continue as a minister. But the big picture is, you have to be a member of legislature. Only then can you be a part of the executive. Or only then can you continue as the member of the executive. That means in parliamentary form of democracy, such as India, such as UK, there can be no strict separation of powers between executive and the legislature. Because executive is drawn from the legislature. If you are part of the legislature, only you can become part of the executive. That is why our constitution, under Article 50 of the Constitution, it does not talk about separation of powers between executive and the legislature. It does not talk about separation between executive and the legislature. It talks about separation of executive and judiciary. Which means if you are part of the executive, you can also be a part of the legislature. If you are part of the legislature, you can be part of the executive. But you cannot be part of the executive as well as judiciary. That is something which we will not allow. That violates the Constitution. And how have we implemented this separation of powers between executive and judiciary? For example, the office of district collector. You're all aspiring for civil services examination, and your idea is, once we clear this examination, we will become an IAS officer. And as an IAS officer, after some years, we may be appointed as the district collector, right? DC, the office of district collector, or in some states known as deputy commissioner, or in some states known as District Development Commissioner, or in some states known as District Magistrate. That's the ultimate objective. This office of District Collector was created in 1772 when the governor in India was Warren Hastings. And this District Collector had dual role, two roles and responsibilities. Dual role in the sense, an executive role as well as the judicial role. Executive role in the sense, as the name suggests, District Collector. What is the principal job of District Collector? To collect revenue. So the taxes which are imposed on the people in that district, whose responsibility is to collect the taxes, collect the revenue, that's the job of the District Collector. This role is what? Executive role. Because taxes are imposed, laws related to taxes are there. To implement these tax laws, I have to collect revenue from the people. I am part of the executive. So one role of District Collector was that of collecting land revenue, District Collector, collector, executive role. And the second role was a judicial role. He would also punish people for committing crimes. So District Collector, he also had the role and responsibility. Whoever has committed murder or rape or dacoity or some offenses against the state, he would punish those as well. So this District Collector was the most important office in India. Sometimes he was known as a tortoise on which the entire government of India functions. The most important office in the colonial times was the office of the District Collector. He had two roles, executive as well as judicial. Same practice we followed after independence as well. But then Constitution says there should be separation of powers between executive and the judiciary. That's Article 50 of the Constitution. And we implemented this when in the year 1973, Criminal Procedure Code was modified, where the judicial powers of the District Collector were snatched. And these powers were given to another body, another individual known as the District Judge. So now the District Collector, he has only executive role. It does not have the judicial role. This judicial role, which used to be performed by the District Collector in the past, is now performed by a judicial body, by a judicial individual. That individual is known as District Judge. So what have we implemented? We have implemented separation of powers. But since ours is a parliamentary form of democracy, and in a parliamentary form of democracy, executive and the legislature cannot be separated from each other. But our constitution also says there should be separation of powers between executive and judiciary. And we implemented this in the year 1973, when the judicial powers of the District Collector were snatched and these powers were given to a District Judge. There can be a question on your mind which I can anticipate. Sir, the Constitution was enacted in 1950. Constitution came into force in 1950. And from 1950 till 1973, why did we not implement separation of powers? Is that not violation of the Constitution? Because you said in the first class itself that we cannot violate the Constitution. If the Constitution says there has to be separation of powers between executive and the judiciary, why for 23 years after the enactment of the Constitution did we not separate executive from the judiciary? For that, you need to understand that this Article 50 deals with directive principles of state policy. And we will discuss directive principle. Directive principles are not enforceable. In a sense, the state can implement DPSP at any point in time. If not in 50, then in 1960. If not in 1960, then in 1970. If not in 1970, then in 2020. If not in 2020, then in 2023. One such directive principle is Uniform Civil Code, which is mentioned in the Constitution under Article 44 of the Constitution. But we have not implemented Uniform Civil Code. Why? Because it is part of directive principle. That doesn't mean directive principle cannot be implemented. That only means that the state will have the right to choose its own time when to implement a directive principle of state policy. Clear? So separation of powers we have implemented, but there cannot be a strict separation of powers between executive and the legislature when it comes to a parliamentary democracy. Because strict separation of powers can come only in a presidential democracy. But we have implemented separation of powers between executive and judiciary. But what about checks and balances? Do we have doctrine of checks and balances? For example, we have legislature. For example, we have executive. For example, we have judiciary. Have we implemented doctrine of checks and balances? Yes. Who keeps a check on legislature? Judiciary. A law passed by the parliament. Parliament is the legislature. Is this law constitutional or unconstitutional? Who will decide? Judiciary. So judiciary keeps a check on the legislature. Who keeps a check on the executive? Both legislature as well as judiciary. For example, a new rule has been issued by the executive. Judiciary can question it. You can approach the court and challenge that rule. If that rule is unconstitutional, judiciary will strike it down. Prime Minister is part of the executive. Council of Ministers are part of the executive. Who keeps a check on them? Legislature. How do we keep a check on how does legislature keep a check on executive? Through something known as no confidence motion. What is no confidence motion? For Prime Minister and his Council of Ministers to survive, they need majority in Lok Sabha. Not in Rajya Sabha, but Lok Sabha. Why? Because parliamentary democracy means Council of Ministers are accountable to Lok Sabha, lower house of Indian Parliament. Because Lok Sabha are directly elected by the people. Rajya Sabha members are not directly elected by the people. We will discuss how they are elected, but later. But when in a parliamentary democracy, Council of Ministers are accountable to Lok Sabha, which means if this Prime Minister and his Council of Ministers, they don't have majority in Lok Sabha, they can be removed from their office when no confidence motion is passed. Which means opposition will introduce a motion saying we don't have the confidence in the Prime Minister. Then there will be discussion on this no confidence motion. Then there will be voting on this no confidence motion. If this no confidence motion is passed, the government has to resign. If this no confidence motion is passed, the government has no other option but to withdraw. So who keeps a check on executive? Legislature as well as judiciary. There are various other tools through which legislature keeps a check on executive. We will discuss that in parliament. But here the idea is to understand doctrine of checks and balances. Who keeps a check on legislature? Judiciary. Who keeps check on executive? Both judiciary as well as legislature. Who keeps a check on the judiciary? Both executive as well as legislature. How? Through appointment and removal. Who appoints the judges of the Supreme Court and High Court? President, who is part of the executive. Who can remove the judges of the High Court and the Supreme Court? President, based on the resolution passed by the legislature. That means legislature has to pass a resolution, send this resolution to the president. President will issue the order. Judges of the Supreme Court and High Court can be removed. So the Constitution envisaged that through appointment and the removal, we will keep a check on the judiciary. But in reality, India is the only country in the world where judges are appointed by themselves through a system known as collegium system, where judges, they recommend names to the president that these are the individuals which should be appointed to Supreme Court and High Court. So although the formal order is issued by the president, but the recommendation is given by the judges themselves. So we can say India is the only country in the world where judges are appointed by themselves. And such is the difficult process of removal of a judge, which we will discuss in judiciary. What is the process of removal? But here you have to keep in mind, such is the difficult process of the removal of a judge that till date, no judge of the Supreme Court or High Court has ever been removed. So we can say there is no checks and balances on the judiciary. In reality, in practice, there is no checks and balances on the judiciary. What did D. Lolme say vis-a-vis British Parliament? That British Parliament can do anything except convert a man into a woman and a woman into a man. We can perhaps say the same thing about Indian judiciary. But I will go a step further. I will say Indian judiciary is so powerful, it can do anything, even converting a man into a woman and a woman into a man. That's the power of the judiciary. Whether that is good for democracy, bad for democracy, that we will discuss in great detail in judiciary. Here the idea was to give a brief overview of the important concepts. Through these concepts, we will understand Indian Constitution better. First, what is a constitution? You know that? Constitution can be unitary or federal. You know that? Indian Constitution is neither completely unitary nor completely federal. You know that? Indian Constitution, we can say, is quasi-federal. But then we have theory of separation of powers. Don't give all powers to one body or one individual or one institution, because that is tyranny. Separate the powers. Create a legislature whose job is to make laws. Create an executive whose job is to implement the laws. Create a judiciary whose job is to provide justice. But Montesquieu said separate them in a watertight arrangement so that one organ does not influence another organ. US Constitution says we will implement separation of powers. But apart from implementing separation of powers, we will impose or implement doctrine of checks and balances. We will keep a check on every organ so that this organ does not violate its constitutional brief. It does not violate the spirit of the Constitution. And what about India? Since we follow parliamentary democracy, where executive and legislature cannot be separated from each other in a watertight arrangement, that is why we have separation of powers between executive and judiciary, not between executive and the legislature. And apart from that, we have doctrine of checks and balances, where legislature is kept under check by the judiciary, where executive is kept under check by the legislature and the judiciary, where judiciary on paper is kept under check by executive and legislature through appointment and removal. But in reality, in practice, there is no checks and balances on the judiciary. Whether that is good or bad, we'll discuss that in judiciary. Any questions as of now? Let me know. That also makes us towards the end of the class, 9:31. Okay, it's 9:30. We'll discuss constitutionalism tomorrow. We'll discuss various types of majorities tomorrow, and then we will start with the preamble. Now, if you have any questions, please let me know. If not, then the class is over for you. Also, I'll take questions for some time. After that, we will not end the class. The class will continue. In a sense, whatever doubts you have, type your doubts. Our subject matter experts will resolve these doubts, answer your questions. And this window will remain open for another half an hour. That means for half an hour after I'm gone, you can still type your questions resolve your doubts with the subject matter experts. Questions, please. And also, you will have, after the class is over, you will have the option of rating the class as well. Let me know if you like this class as well. That will be quite helpful. Can we leave? If you have any question, Mantaj, please ask. If not, then you can leave. Presidential form of democracy for US, yes. Through appointment and removal, how can legislature keep a check on judiciary? By appointing those persons as judges who are constitutionally aware, who are honest, who are people of integrity. And if they don't do their task better, we have the power to remove them as well. So to keep a check on judiciary through appointment and removal, by appointing good candidates as judges and by removing those who are not doing their job honestly. How to access annotated PPTs and additional reading material? It will be available on the app. We will also send you the mail. Sir, can you explain historical background of Indian Constitution, which is mentioned in Laxmikanth? That we will be discussing in modern history. So that's why I said right at the start, topics such as constitutional development, Pitt's India Act, Regulating Act, Charter Act, Indian Councils Act, all will be discussed in modern history. Watertight arrangement means one organ should not influence the other. If a container is watertight, that means there will be no spillover. So you will not influence your outside environment. In the same manner, executive will stay in its own domain, not influence legislature, not influence judiciary. Thank you, Vikas. Which chapters we are ready? And M. Laxmikanth, then after I pen down. Gumnam, don't read anything from Laxmikanth today. I'll tell you tomorrow onwards what you can cover from Laxmikanth, because what we have discussed today is not there in Laxmikanth. Where do we get to know about various cases such as Keshavananda Bharti? From these classes. Attend regularly. Where states are not consulted in changing the constitution. Fundamental rights, directive principles, fundamental duties, various other provisions of the constitution, states are not consulted. No confidence motion means we have the opposition in Lok Sabha. For example, Congress, DMK, Trinamool Congress. They issue a motion in Lok Sabha that we don't have the confidence in Prime Minister Modi. Remove Prime Minister Modi. If their motion gets a support by Lok Sabha, gets the majority in Lok Sabha, that means majority of the members of Lok Sabha agree with the opposition, then Prime Minister has no other option but to resign. Which means legislature, through this no confidence motion, keeps a check on the executive. Central tendency of Indian federalism, can you describe again? India, we say, is a federal constitution, federal polity. But there are some provisions in the Indian constitution which are biased in favor of a strong center, which gives more powers to the center as against the states. Those provisions we call centralizing features of Indian federalism. For example, Article 3, for example, citizenship, emergency provisions, audit, election machinery, all these we will discuss one by one. How is executive chosen in United States? Shalu. People elect the president of the United States, and then who is head of the executive. Then the president of the United States choose his own set of people who are appointed either as finance heads or external affairs head. So that is the personal discretion of the president. He gets to choose his own team. That is it for today. Thank you so much for staying with me. See you again tomorrow, 6 o'clock in the morning. Till then, have a great time. Stay safe, stay well. If you have further doubts, reach out to the subject matter experts. They will be here till 10 o'clock. Bye-bye. Take care.